Thank you, Your Honor. Good afternoon, and may it please the court. My name is Sierra Rogers, counsel for Gordon and Stella Beckhartz, the appellants in this matter, and the debtors in the underlying bankruptcy case. I would like to reserve 7 of my 20 minutes for rebuttal. Your Honors, this case is about the bankruptcy court's power to enforce its orders and award appropriate sanctions. Section 105 of the Bankruptcy Code authorizes a bankruptcy court to issue any order, process, or judgment necessary or appropriate to carry out the provisions of the Bankruptcy Code. That power gives the bankruptcy court the authority to preserve the integrity of the judicial process, resolve disputes orderly and expeditiously. During my time today, I want to make 4 points to Your Honors. The first is that the district court did not give proper deference to the factual findings made by the bankruptcy court. Second, the bankruptcy court properly interpreted the confirmation order and found that it was not clear or ambiguous. Third, the bankruptcy court considered Taggart and determined that it did not absolve the appellees of their contemptuous conduct in violation of the confirmation.
Where did the bankruptcy court do that?
I'm sorry, Your Honor.
Where did the bankruptcy court do that?
The bankruptcy court considered Taggart at length at the evidentiary hearing on June 18, 2020. There is not a reference to Taggart in the bankruptcy court's order granting sanctions against the appellees, but through the exchange between counsel and the judge at the bankruptcy court, there was a conversation about whether or not Taggart applied, and if so, how it would apply.
The bankruptcy court seemed fairly confused as to what to do with Taggart. And it didn't say anything in the order about it, and I don't remember reading anything in the order that applied the standards from Taggart. So in that circumstance, what confidence do we have that the bankruptcy court did indeed apply the appropriate law?
Your Honor, I would say the fact that there was an exchange at the evidentiary hearing where there was a discussion about Taggart, what its standard was. There was also a question and answer with Judge Hummerkaus and counsel about whether or not she understood the issues as they were raised by the appellees. And during that exchange, appellees acknowledged that Judge Hummerkaus had in fact interpreted their issue. And
Counsel, let me ask you a follow-up to Judge Agee's question. I'm looking on pages 17 to 18 of the joint appendix, and this is where the district court says, this is at the bottom of 17, a finding of civil contempt is warranted when there is a demonstration by clear and convincing evidence of, and then it lists 4 factors on the top of 18, and that's not the Taggart standard that the bankruptcy judge is quoting there. So I have the same concern as Judge Agee. It doesn't, at least based on the order, it does not look to me that the bankruptcy judge is applying the Taggart standard. So what do I do if I conclude that's the case?
Your Honor, first I would say that the Taggart standard is applied. Before you get to the Taggart standard, you have to apply the Ashcroft standard of finding of civil contempt. And then if there's a finding of civil contempt, as was done in the bankruptcy court, then determine whether or not there's a fair ground of doubt that was referenced under the Taggart standard. And in Taggart, the court talks about whether there's a continuous violation of the order. In this case, Judge Hummerkaus's order does reference a continuing violation. Again, while it does not specifically reference Taggart, I would say that language and using the language from Taggart is her application of the fair ground of doubt Taggart standard.
Can I ask you a follow-up? You've mentioned the continuing violation, and this was another question I have about your position. I understand that you think that the creditor violated the plan of confirmation order in numerous respects, but it would be helpful for me, what is the first thing that they did? Like, what is the first moment in time, in your view, where they were in violation of the confirmation order? What was that thing, and when was that thing done?
Thank you, Your Honor. The thing that we say was the first time the appellees violated the confirmation order is July of 2014. The appellees, specifically Shell Points, began servicing this obligation in June of 2014, June 25th, I believe, 2014. Immediately thereafter, they sent a letter to say that they had taken over the servicing and a follow-up letter to say that they found that the Beckharts were $50,000 in arrears under their obligation under the plan. So we would say that's the first violation of the confirmation order.
And just a little bit more, what portion of the confirmation order did sending that letter violate?
So if we look at the confirmation order, it's in the record starting on page 66, Your Honor. And in the order, it says on page 67 that the plan is confirmed subject to the following modifications. And then it provides a amended or an adjusted treatment to BAC Home Loans. And BAC Home Loans is the predecessor in interest to both Shell Point and Bank of New York Mellon, both of the appellees in this case. And in that, it says how the secure treatment of BAC would be treated.
So what happened to the arrears as of the time of the bankruptcy?
Thank you, Your Honor. So the arrears were treated in the confirmation order. And this is clear because in the claim 29.
What page are we looking at to see that?
In the record, it's page 201 and 202, Your Honor. And that's claim 29 that was filed by BAC on February 26, 2010. And that proof of claim, the purpose of the proof of claim is for the creditor to put the debtor as well as the world on notice as to what they say they are owed. And if I can point, Your Honor, to specific sections of the proof of claim form on page 201, the box that's numbered 1 says the amount of claim as of the date the case is filed, and it lists $432,626.09. And also in that same box at the end, it says, check this box if this claim includes interest or other charges in addition to the principal amount of the claim, attach an itemized statement. Then on page 202 of the record, Your Honors, you see that BAC then attached an itemized statement that calculates the arrears.
We can see what the amount of the arrears is and what the total amount of the claim was. But in looking at the class 9 treatment in the confirmation order, how would we or the creditor know what was to be paid and when and what that covered?
So the treatment says that the claim, the secured claim is the lesser amount of the value of the property or all outstanding principal and interest due on the petition date. Claim 29 that we were just looking at on page 201 tells us the total amount that was owed on the petition date, and that was BAC's own calculation of what it was owed. So the confirmation order doesn't need to include a sum certain. That information was available, and you read the confirmation order, the plan, and the claim together to be able to discern that amount.
So we know that arrears is included in principal and interest?
Yes, Your Honor, because that's the amount that's included in their claim. If you look back on page 201 of the record, in box 4, towards the bottom of that box, it says the amounts of the arrearage and other charges as of the time the case is filed, included in secured claim, if any. And then BAC included the $22,836.40, which is the itemized amount from page 201 where they calculated the arrears.
I appreciate your explanation. Now, I didn't see that in the briefs or anywhere in the district court or the bankruptcy court documents. Was that explanation made?
I believe that we talked about in the opening brief to this court, Your Honor, we talked about the total claim. And there was an argument made about the total claim, including the pre-petition arrears. So I believe we did make that argument in our opening brief.
But the creditor says, and they can speak for themselves, that we didn't know what to do in terms of the arrears. And we also couldn't tell from the confirmation order what the amount of payment was to be. So with those questions, doesn't that go to the reasonable doubt issue under Taggart?
I would say yes, but I would say, Your Honor, that is not a genuine argument. And the reason why is because of the letter that Shell Point sent to the Beckharts on January 15th, or that's dated January 15th, 2020, and it's in your record starting on page 314. Because in that letter, which is the second letter that they sent to the Beckharts, there was one letter sent dated December 11th, 2019, and then a follow-up letter sent on January 15th, 2020. And in the follow-up letter, the Shell Point goes through exactly the same process that I just went through to be able to point out to Your Honors what the amount owed was on the effective date of the confirmation order. So it's disingenuous for Shell Point to argue that they couldn't figure it out when they in fact figured it out and adjusted the Beckhart's account in an amount equal to 24 monthly payments and essentially brought the account current in January of 2020. And that was before the motion for contempt and sanctions was filed, before there was an evidentiary hearing. They figured it out and applied the same exact logic that I just did to be able to answer that question without any assistance from outside counsel with their internal bankruptcy department. So if they could figure it out.
When did they, the opposing counsel can also answer, when did they use outside counsel?
The evidence or the testimony, excuse me, that was presented before the bankruptcy court is that they had done it on a continuing basis over some period of time. As I stand here right now, I don't know when they started and when they stopped seeking advice from outside counsel. But I would suggest, and what we've argued in our briefs, is that looking to outside counsel wasn't necessary when their internal bankruptcy department audited the account beginning in December of 2019 and determined approximately a month later that there had been an error in the servicing and that the servicing did not in fact comply with the confirmation order. That's their.
What about their argument about we relied on the advice of counsel for this? Advice is probably wrong, but they relied on it.
So I think there's 2 points to make there, Judge. The first point is that reliance of counsel is not a defense to civil contempt. That's been clear in the Fourth Circuit. I believe this court's opinion in Walters from 1989 says that. It's been the longstanding Fourth Circuit authority on that. But also in
bankruptcy court statement where it says it's always reasonable, I think, to rely upon the advice of counsel.
The second part that I would say, Your Honor, is that advice has to be from counsel that's qualified to be able to answer the question. And there's case law in the Fourth Circuit that specifically says you can't hide behind counsel in their omissions. And what I would say here is there's no evidence in the record, and there was no evidence before the bankruptcy court that the counsel that they sought and got advice from was counsel qualified to interpret a bankruptcy court order. I would suggest that having counsel that maybe does traffic violations wouldn't be the appropriate counsel to seek to interpret this order. And Shell Point put on no evidence that their reliance on counsel, even if they did in fact do that, was reasonable, because there was no evidence that the counsel that they relied on was able to interpret this order, had any bankruptcy experience, or would have been able to address the complex nature of a Chapter 11 individual confirmation order.
I'll ask you a question I'd just like to have you address in rebuttal. What is the nature of this loss of fresh start damages, and what authority is there for the proposition that the bankruptcy court can award that? It looks like some weird combination of emotional distress, which this court has said you can't do, or punitive damages, which the district court said it wasn't doing, or presumed damages, which I'm not sure you can do in this context. So I know your time is up, but if you could address that on your rebuttal, I would appreciate that.
Yes, Your Honor. Thank you.
All right. Thank you very much, Ms. Rogers. Mr. Chastain.
Thank you, Your Honors. Aaron Chastain for the appellees. May it please the court. Your Honor, the word Kafkaesque gets used a little too much in legal parlance, but we really think that that's the description of this case. We were never on notice as to what we were required to do under the confirmation order. And throughout this case, we have heard various explanations as to what conduct we are supposed to do. But the problem is, this is not a case about whether we complied with the confirmation order. This is a case under the Taggart standard as to whether we had any fair ground of doubt as to the meaning.
Counsel, here's the dilemma, I think. Imagine I think the following two things are true. Imagine that I think there is room for debate about a whole bunch of different things about this order. But there is one thing I think there is no possible room for debate, which is that when your clients pursued the foreclosure action, there is no conceivable argument that that did not violate the confirmation order. So what am I supposed to do with that? I mean, it's continuing with the foreclosure action even after being on notice that the foreclosure action is no, I mean, I understand the creditor to have acknowledged that it was a mistake to continue with the foreclosure action. I don't see any conceivable argument that that didn't violate the confirmation order. So what do I do with that?
Well, Your Honor, we respectfully disagree with that. I mean, the dispute one isn't the same. I mean, either they were delinquent and in default on the loan, as we believe they were for a period of a long time, that would call for foreclosure, or they weren't, we were mistaken.
Okay, so let me ask it this. We can debate what exactly the confirmation order was supposed to give them, but the one thing that seems very obvious is that it was supposed to give them something. And what concerns me is that your clients seem to proceed under the assumption that the confirmation order gave them literally nothing. I guess one way to say it is, regardless of the position your client is currently advancing, when your client was filing for foreclosure and sending them all of those letters, what benefit at all did you interpret the plan as having given the debtor in this case?
Well, Your Honor, I can't speak to what was going through the mind of counsel at the time, but there is a very plausible explanation for the benefit. And that is there was a period of time during the pending of the bankruptcy that the Beckharts did not have to make any monthly payments. The Beckharts were reorganizing, I think it was 17 different rental properties, liquidating some of them. The original proposed plan had them liquidating this one. It would have been plausible to think that on November 25th, 2010, they were going to make a lump sum payment to cure their arrearages, bring the account current, and then pay as the terms of the note dictated on a going forward basis. So you think it was
objectively reasonable for your client to think that the only thing that bankruptcy had given the Beckharts was a pause on having to make payments, but the moment the plan is confirmed, we go right back to where they were vis-a-vis your client?
Absolutely, Your Honor. Again, this is a bankruptcy that involved, I think, in upwards of 24 claims. So if we're looking at this specific one, that's why it sounds sort of far-fetched here in hindsight, some 10 years removed. But at the time, I think that was an absolutely reasonable interpretation of what the purpose of this plan was. And it's consistent with the original proposed plan, which was a proposal for selling the property in liquidation. And so, Your Honor, within the Taggart framework as to whether there was an objectively reasonable basis, absolutely, Your Honor. We think that was an objectively reasonable explanation for the thinking at the time, and certainly on a continuing going forward basis. And Your Honors, I really want to walk through what's in that Class 9. I know you've looked at it, but even now we keep hearing different interpretations about what's in dispute, what's not. There are 5 elements in Class 9. I think that's the easiest way to think about it. There's an element that talks about the adversary proceeding. The Beckharts were hoping to get the lien removed from the property entirely. And so there's a contingency in the class to treat that. They were unsuccessful. We'll take that out. There was the value of the claim. The value of the claim was not in dispute. It was $432,626.09. That was the amount of the claim. There were no post-petition petitions for interest or costs. That was the value of the claim. There was a first payment date. Now, this is the only one that really has any bearing on what we're talking about today. It says the first payment will be November 25th, 2010. How much is that first payment? Nothing. It doesn't say anything about the amount of that first payment. There's default notices. Again, those don't have any bearing on what we're here about. And then you have the savings clause. You have except as modified herein, debtor shall continue to pay creditor's claim according to the original loan terms. So the only one of those that bears on the original loan terms is that first payment date. Okay, so how do we read this? Well, throughout this case, we have heard 4 different interpretations of how to read this. In their motion for sanctions, they cited the wrong class. So we weren't on notice even when this got started as to which interpretation we were supposed to follow from the beginning. The first one we heard was reamortization of the loan. That was something that was proposed in debtor's counsel's letter to us. It was something that Mr. Beckhart testified that he thought that's what he got from the confirmation order. Well, the problem is, Your Honor, that's absolutely not in there. That's very far removed from what's in the final order. It's what was in the proposed plan, but it's not what's in there. So
that's part of my consternation with your position, is that the arguments in the lower court seem to be, well, we had our attorneys looking at the proposed plan, which it turns out is different from the order. And so we were getting conflicting advice or bad advice. But now in this court, you're saying, well, even the proposed orders, there's no way we could have known. I mean, I think you made that different argument, didn't you? I mean, the plan is different than the order.
That's correct, Your Honor. I'm sorry, I'm not following. I believe the advice that we saw from external counsel, as documented in the record, had to do with the final order. I don't think it's centered on the confusion between the proposed plan.
I believe the testimony was that it was based on the plan. Counsel were giving us interpretations based on the plan and not the order. It was the quote from the testimony below.
I think that's your 30B6 witness testifying there.
Testifying that the advice of counsel is based on the plan and not the final order.
So opposing counsel says that was ineffective advice, and I guess in effect that deficiency is attributable to you.
Well, let's back up a second and talk about the nature of the advice. We are not arguing that advice of counsel is a blanket defense to civil sanctions. It's not. It is relevant to the inquiry under Taggart as to whether there's a reasonable objective understanding that would provide a good faith basis for believing.
And you
conduct.
further would agree, I assume, that subjective good faith is also not an absolute defense.
Yes, Your Honor. That is clear from Taggart. Subjective good faith is not a defense. It's an objective standard. Was it reasonably objective? Now, but I will caution Your Honors, the Second Circuit grappled with this in the Enri Gravel case. They applied the Taggart standard. And in that case, there was an order from a bankruptcy court that declared a debt to be current and precluded the creditor from trying to, in any proceeding, dispute that the debt was current. Well, the creditor in Enri Gravel sent notices saying that the debt wasn't current. I think there were late fee notices. The Second Circuit found even that sort of conduct is not sanctionable under Taggart. It found that there was an objectively reasonable basis for room for dispute in that order. Well, Your Honor, I use that example because I think our case is so far removed from that. There, it's very clear.
I assume you would agree that we wouldn't have to adopt that. We wouldn't have to adopt that extreme definition of objective reasonableness to rule for you, as I guess what you're going to say?
Precisely, Your Honor. I'm saying if the Second Circuit is willing to say under Taggart that's not sanctionable, we don't have to go nearly that far to say Taggart has an objectively reasonable standard. And here we had an objectively reasonable basis for reading the order as we did. Your Honor, I will quickly address the argument as to Taggart's application to a Chapter 11 case with the Section 105A basis for injunctions. Your Honor, every court that's looked at it, as far as I can tell, has applied Taggart in the Chapter 11 context, and they've applied it in the Chapter 13 context. They've applied it in every context. In fact, outside of bankruptcy, this court has applied Taggart.
Made that argument on brief, but she did not make that today. I don't know whether that's waived or not, but.
Yes, Your Honor. It was in opposing counsel's brief. I raised it now simply because I won't have another opportunity to raise it. The argument was not raised for the bankruptcy court. It was acknowledged between our counsel and between the bankruptcy judge, but it was not disputed at any point before oral argument in the district court that the Taggart standard would apply. Your Honor, I'll walk through the other possibilities for how to read this order because our case is focused on the Class 9 treatment in the final confirmation order. We would suggest that this court can look at Class 9 in that order and make a determination as to whether what is the reading, what is this Kafka-esque reading that the bankruptcy court did not even talk about in her order, that no one really talked about in the bankruptcy court during the evidentiary hearing. And we're fine. Supposed to make,
there's a statement in the bankruptcy court's opinion that your client effectively did not even contest. I mean, the bankruptcy court said you didn't even contest contempt, but I guess that logically encompasses not contesting whether you violated the order. I mean, I guess I'd say is my intuition would be you would not be allowed to tell a bankruptcy court we don't contest that we violate the order, and then when you're held in contempt to turn around and argue that you didn't violate the order because that is baiting and switching the bankruptcy judge. So could you first address the question of whether in the bankruptcy court you even argued that you didn't violate the order?
Oh, yes, Your Honor. We contested in the bankruptcy court that it was not a violation under Taggart to do what we did. Hold on. Not a violation of Taggart is different than not a violation of the order. Yes, Your Honor.
So where in the bankruptcy court did you actually argue that you didn't violate the order?
Your Honor, I'm not sure that argument is in the bankruptcy court simply
because. How can you
because.
turn around and ask us to reverse the bankruptcy court on the grounds that you didn't violate the order when you never even argued to the bankruptcy court that you didn't violate the order? We're
asking this court to reverse on the basis that we had an objectively reasonable reading and justification for what we did under Taggart, which is dispositive of the bankruptcy court's order, regardless whether it was a violation of the order or not. We were not even on notice as to what that potential violation of the order could be because it was not asserted in pleadings and it was not asserted at any time in the bankruptcy court. It would have been a pure shot in the dark to say that this is what the order requires and we hit that target. It was a much more reasonable approach to say we're not even sure what the order requires, and because the Taggart standard applies with force in that context, we went under Taggart. That argument was preserved in the bankruptcy court. And Your Honor, I suggest the bankruptcy judge just made a mistake in drafting this order. I don't think that's any commentary on actually the proceedings or her judgment as to our arguments about Taggart, about the order, or anything else. I think maybe it was confused with the simultaneous proceeding in the BSI case, or maybe not, but it was just a mistake. And I think that this.
What would you say at the end of the day is if we determine, for example, that the bankruptcy court did not follow Taggart and that Taggart is the applicable law, are we to proceed on and in effect, go to the merits and reverse with directions to enter judgment for you? Or do we say the bankruptcy court applied the wrong standard and let it have another shot?
Your Honor, we're asking to reverse and render. Again, it comes down to the language of the confirmation order, which is clearly before this court. There's no factual determinations to make about that language. Reading the confirmation order, what does it require of the parties? Is what we did a reasonable basis in reaction to that order? And Your Honor, we absolutely submit that it was. Again, reamortization is one of the options. That's out. That's not within the constraints of Class 9. A lump sum payment at the end of the loan was the other suggestion. That might be a valid workout option, but it was not what was in the confirmation order. We have forgiveness, and this is now what the Beckharts are arguing that we had an obligation to do in the first place. Well, Your Honor, I encourage you, look at Class 9. There's nothing in Class 9 that says bring the indebtedness current, forgive parts of the loan, bring the escrow back even. We also fixed the interest rate. That's something else we did when we corrected the account. We also, I believe, no, we didn't reamortize, but we did fix the interest rate to a fixed rate. We granted a retroactive interest rate that was more favorable than the one they would have had under the terms of the loan.
To follow up on Judge Agee's question, what do we do if we think that in certain respects, both the bankruptcy court and the district court were wrong? Because, you know, we focused on the bankruptcy court and its failure to discuss Taggart. There's some language in the district court's opinion that I'm worried about too. I'm specifically thinking about on page J358, where the district court, says undisputed evidence that supports a finding that Shell Point acted in good faith. That sounds really, really, really close to saying that subjective good faith is a defense, which you have conceded, I think correctly, is not a defense to civil contempt. So what do we do if we think that both the bankruptcy court and the district court got things wrong?
Your Honor, you absolutely can still reverse. I mean, the contents of your opinion can clarify that subjective good faith is not a defense to the imposition of sanctions. That wouldn't really even require walking back the district court's holding. He's making a factual holding. It just makes it clear there's no legal significance to that holding. So it would be grossly inefficient and frankly unfair to my clients to remand this to start over when this issue was fleshed out. This is not something that took the courts by surprise and now we're having a discussion about Taggart. That was the argument at the hearing. We've had the opportunity to litigate that throughout the case. And so now it's time for this.
Counsel, what concerns me is that bankruptcy court, listed 6 different ways that she thought your clients violated the order and why contempt was warranted. And we've, the district court has talked entirely, and we're pretty much talking entirely today about kind of one part of that. But there were more reasons for the bankruptcy court, and the bankruptcy court heard the testimony, saw the evidence. Contempt is something that, requires that kind of level of familiarity with the case. And it seems like quite a jump for us now to say, well, we can just read the face of the order and know that no one ever could be held in contempt for acting as though there had been no bankruptcy at all and just continuing to try to collect the full sum. Why shouldn't we just send it back to apply the correct standard?
Well, Your Honor, those findings in the bankruptcy court's order all stem from the dispute over the treatment of Class 9 and what happened on that November 25th, 2010. They all come out of the fact that at that date, my clients believed that the original loan terms controlled, and therefore there was an outstanding indebtedness and immediately owed amount to reinstate the loan. It was past due, it was in default. Everything else came out of that. It was a binary determination. Were the Beckharts in default? Their position is, no, we weren't. We were supposed to be current as of November 25th, 2010, when we made our first payment. And my understanding is, Your Honor, that the bankruptcy court's findings all come from that. And so since that root cause issue is before this court, there's no reason this court can't reverse all those findings by the bankruptcy court. Your Honors, with my time running down, I'll briefly address the other arguments about the sanctions award here in this case. Even if this court is not inclined to agree with the district court that the sanctions were inappropriate, the evidence absolutely doesn't support the amount of damages that were awarded. To refresh this court's recollection, the testimony in the bankruptcy court was that Mr. Beckhart spent about 200 hours working on these issues. He specifically said he had 40 hours lost out of his business. He did not at any time provide any sort of financial information as to the actual damages costs that he incurred because he was working through these issues. And the courts in this circuit are very clear. It's the burden on the party seeking sanctions to put on that evidence. And two, it has to be out-of-pocket actual losses to be compensable. And so, Your Honors, without any evidence at all, his lost time is not compensable. Even granting every unreasonable inferences in his favor, the most he could have attested to was that he spent 40 hours he would have otherwise spent on his business. As far as what that was worth, all he provided to the court was a single sentence description that because he had 2 degrees, his time was estimated to be worth $200 an hour.
Courts in this circuit required. Do you mean this court, or do you mean which were of course bound by things that this court has said, or do you mean courts whose decisions that this court is not bound by?
This court in the General Motors case said the burden was on the party seeking the sanctions to prove causation and the amount of damages. It believed that there were a few district court cases that adopted that holding, but it was this court and the courts of this circuit. Without that proof, Your Honors, and again, the burden is on the Beckharts here. They're seeking sanctions. They, in their briefs, have argued that we have a duty to prove a negative, to prove he was not actually damaged because he's an entrepreneur and his income is difficult to track. That's not how it works. If they had put on evidence as to what his time was worth and made it correspond with his revenue as a person who holds properties and rents them out, then we might be having that discussion because we'd have to rebut it. But that evidence is not in the record.
What is this idea that he can only be compensated for the amount of time that he would otherwise have spent on his business come from? I mean, this sounds awful. I will say, reading the record about what this person had to do because he kept getting these notices, it sounds terrible. It sounds miserable. It sounds like the sort of thing that would consume hours and cause tremendous countless. Where does this idea that the only thing he can possibly become, assuming a violation, I agree, I understand you don't agree there's a violation, but assuming that there was a violation of the bankruptcy court's order, it was a violation of the very thing bankruptcy was supposed to have given him and it was wrongfully taken away from him, where does this idea that he can only be compensated one for time that he would have otherwise spent on his business come from? I personally place quite a bit of value on the time I'm not at work, and I would be very, very angry if someone made me spend hours and hours and hours straightening out something that wasn't my fault.
It's a fair question, Your Honor, and it's the reason my wife wants to prepare invoices for the city of Birmingham when they send us bad water bills. But it goes back to a common law doctrine, and I'll be candid with the court. This is based on a law review article I read when I was researching and writing the briefs for this case. It is actually cited in our brief, not directly, but as an internal citation. So I just beg the court's pardon if I misconvey this. It's been a while. But my understanding is there was a common law rule that drew a strict distinction between what was compensable and what was not. In the translation, it was not a rule about work time versus leisure time because it comes from a time when that wasn't really even a clear concept. But the courts have historically, for I think 150 years, used that common law principle and applied it to say that for the rule we have today, that's widely accepted in many states, that time that you are actually losing economic value, similar to contracts kind of theory, is compensable. Time that you are using on your leisure or any other kind of activity is not something a court can redress through sanctions. And I see my time has expired. Thank you, Your Honors.
Thank you very much, Mr. Chastain. Ms. Rogers, you've got some rebuttal time. Let me ask you as you begin, there was an argument made on brief, I believe, that Taggart was not applicable in a Chapter 11 setting. Is that still an argument you put forth?
Yes, Your Honor, we have not waived that. We believe that that is an argument that this court should consider. And in response to the appellee's argument, where it was made that courts have applied the Taggart standard to Chapter 11s, I respectfully disagree and say that none of those cases are cited in the briefs. In the Gravel case that opposing counsel specifically references, the Second Circuit case, and the issues there were Chapter 13 cases, and the injunctions that were at issue was the discharge injunction in a violation of Rule 3002.1. Those are very different issues than what we have
to win this issue in order to win this appeal. I guess I will say, assume that my reading of Taggart suggests that it is implausible to say that Taggart does not apply to this kind of bankruptcy. If I disagree with you about that, does that mean you lose this appeal, or can you still win this appeal?
No, Your Honor, we still win. And the reason is because there's no fair ground of doubt as to what the confirmation order required Shell Point to do. And it's no fair ground of doubt because in January of 2020, Shell Point goes through the process, which they should have done in June of 2014, to determine what their obligations were. So even if this court disagrees and finds that Taggart should have a
that you made either to the bankruptcy court or the district court in terms of no fair ground of doubt?
Yes, Your Honor, that was made to the district court specifically. In the district court's opinion, it says that it disagrees with my argument that Taggart doesn't apply and focused nearly primarily on the fact that the appellees relied on the advice of counsel. I would submit that the district court erred in its reversible error because the cases that it cites are cases related to Rule 11 and Rule 9011, which aren't applicable to the determination of whether or not there has been a fair ground of doubt on a violation of Section 105 of the Bankruptcy Code.
Bankruptcy court would have been the finder of fact here. Did you ever make the Taggart no reasonable ground of doubt argument in the bankruptcy court?
Yes, that goes back to the discussion I was referring to previously. And in my opening brief to this court, I include a direct cite from the transcript about the conversation that was had in the bankruptcy court about Taggart not applying and why it should not apply.
Were you part of that conversation or was that counsel for the creditor?
I believe all of us were involved. The part of the transcript that's cited in my brief, I believe, focuses on the conversation between Judge Hummerkaus and the appellee's bankruptcy counsel. So, Your Honors, I would say that I don't have to win Taggart to still win in this case, but there has not been any decision in this circuit on how wide to apply Taggart, and I would suggest that it should be a narrow application. I also want to respond to the question that was asked to me at the end of my opening statements about why the loss of a fresh start is compensable. And I respectfully disagree with the way that the question was posed, that the loss of a fresh start is tantamount to emotional distress damages or punitive damages. This court has specifically said in the I think it's the Valley Historic case that the loss of a fresh start, and the Supreme Court has said in multiple occasions that the loss of a fresh start is a basic principle of the bankruptcy code. And the loss of the fresh start in the Kirkbride case, which is a case out of the Eastern District of North Carolina, as well as the Bock case, B-O-C-K.
How do you put a dollar number on that? I guess I'm a little troubled by the fact that there has to be evidence to support the figure, right? And I don't know where do you get the evidence to put a dollar figure on loss of a fresh start if emotional distress and these sorts of things are not what we're talking about?
So you have a tangible loss in this case, Your Honor. You have the tangible loss of the erroneous credit reporting. And Mr. Beckhart testified about the erroneous credit reporting, saying that the account was behind when it was not in fact behind, as well as the erroneous credit reporting where the appellees have stopped reporting this account on Mr. Beckhart's credit at all. So he's losing the benefit of on-time monthly payments, which is a way that one's credit score is increased or improved after the bankruptcy process. And what the courts in Kirkbride and Bock said was that erroneous credit reporting was a tangible connection to the loss of the fresh start that a dollar figure can be put on. Now, there is not a magic formula.
Here would you decide whether that's 10,000, 20,000, or 30,000?
I would say that that's a factual finding, and within the reading of the record and the evidence before the bankruptcy court, how many times these issues occurred, how long these issues occurred, all of those things would be factual determinations that the bankruptcy court had the ability to hear and determine. But I don't think there is a way to say one violation equals X number of dollars, two violations equals Y number of dollars.
Well, you could imagine a situation where, say, this incorrect credit history resulted in being denied a loan, or resulted in something that maybe is measurable, in which case you really could find a way that there's evidence to put a dollar figure on. But I don't know, it didn't sound like there was anything like that here.
I think there was, Your Honor. Mr. Beckhart's testimony is that he's an entrepreneur, and opposing counsel mischaracterizes his testimony as what his business activities were. In the briefs, as well as today, opposing counsel says that Mr. Beckhart's business activities were real estate development. What he ignores is Mr. Beckhart says that he hasn't been doing much real estate development at the time of the evidentiary hearing, and his business activities focused on inventing. He creates ideas to fill holes in the market and then brings those ideas to market. That's why his engineering degree has an impact on his ability to do his business activities. But also, as an entrepreneur, somebody who is looking for funding or who is looking for loans to be able to acquire new real estate as well as bring products to market, he's going to have to go out to get loans. And I can't quote a specific place in the record, but I believe there was testimony from Mr. Beckhart where he addresses the fact that he hasn't been able to get loans. I don't want to say with certainty because I don't have that page number or anything in my head right now. But I think that there is enough evidence in the record for the bankruptcy court to determine that the erroneous credit reporting that was obviously discussed before it had a tangible impact on the business activities that Mr. Beckhart was be able to do. And I see my time is over.
Thank you very much, Ms. Rogers. I want to compliment both counsel on their arguments today. As you probably know, it's our custom to come down and greet counsel at the end of the argument, but that's a prohibited activity at this time. So we hope you'll come back in the future and we can greet you in person. So we'll move on to our next case.
It would turn the fifth. The Comte Nord exercises ambiguity about it, and so the United States is going to be used for that.
Here.
States brought one condemnation action that it was all for one cemetery expansion project in terms of the just compensation due for the property. That's not the law, Your Honor, respectfully. Whether it's one project, whether it's one taking, that doesn't dictate one form of just compensation for all the property. The relevant inquiry is what property was taken, what was lost by the condemnee, and what needs to be paid for that property. The reason you haven't seen a fact scenario like this where the United States and the county agree it's being offered substitute facilities as just compensation is because in
What exactly?
Your Honor, the take of the was so that both sides expert appraisers found the highest and best use is for residential development.
My impression was that compensated in these other roads, but that you think that parcel had more value it was property that could be developed that's not being compensated. It's like it needs to be topped off to reach its value. Is that a correct interpretation of what you're saying?
No, Your Honor.
Okay, tell me.
Yes, it's not a top off. And again, this is not a double or hybrid compensation prop segment, almost the same location, but it's being shifted to the south to create more contiguous space for the cemetery. That property, that Columbia Pike, is compensation for the taking of Columbia Pike. That was the way the parties negotiated it. That's the way that the evidence supports it. And at the end of the day, it doesn't serve as just compensation also for the Southgate parcel. There's not a shred of evidence, Your Honor, that the Columbia Pike property would be any different if Southgate had not been taken also. The government's position is that if we take property...
Places that I thought the county represented that losing Southgate and the other road, Joyce Street, that the Columbia Pike, which if you look at the pictures, seems substantially improved over what it is today, along with the South Nash Street, that was the mitigation for taking specifically Southgate, Joyce Street, and Columbia Pike.
Your Honor, I'd submit that the record demonstrates, and again, this is a summary judgment ruling. What we're asking this court to do is to reverse the grant of summary judgment and allow the case to return to its normal course, rather than determining that these issues have been determinatively demonstrated.
Do you disagree on that point? Do you disagree that the district court it is the district court's job to find the facts when it comes to is this one taking, what form of compensation is appropriate, but then it's the jury's responsibility to determine the actual dollar figure, the actual award. You seem to proceed below as though this was the district court's job to find these facts, but then there were some hints in your brief as though you were saying, well, the district court shouldn't have done this. And I just wanted to check on what your interpretation of 71.1H is.
Sure, Your Honor. The county promptly and timely demanded a jury trial on the issue of the amount of just compensation.
Right.
The United States brought a novel motion, the same one as summary judgment.
But what do you think that means? The amount of compensation? That's the dollar.
It's the fair market value, Your Honor. Yes.
Okay, but the district court, it seems like you thought before the district court, it's the district court's job to determine these preliminary facts that we're talking about now. Is this one project? What form of compensation is appropriate?
Yes, Your Honor, but there isn't any case where the district court has found that substitute facilities are appropriate when, for example, there's only two instances. In every single substitute facilities case, there's been the presence of one of two circumstances. One, that the property has an indeterminable fair market value. It's just, it is a major road. It is a county facility. It is public works that doesn't have inherent fair market value. It's stipulated in this case that the Southgate parcel has significant fair market value. It does, and both sides' appraisers have valued it in 7 to 8 figures.
So imagine for the sake of argument, and I'm not saying I necessarily think this, and I'm not asking you to agree with it or concede it, but imagine that we were to conclude that the relevant test, which is what the district court basically said, is what you're getting an adequate substitute for what it is you're losing. Imagine that is the legal standard. Do you think that the question about whether X is an adequate substitute for Y, is that a factual question to be determined by the jury or the other fact finder, or is that a legal question for the district court? You know what I'm saying? So if we posit that the question is the adequacy of the substitute, who decides whether Y is an adequate? Because the district court seemed to think it was the district court who decides whether X is an adequate substitute for Y. Do you agree with that?
If the question presented, if I'm understanding, Your Honor, the question presented was the adequacy of the substitute facility.
So yes. I'm going to take, I don't know, one of your folders, and I'm going to say, well, the bad news is I'm not going to give you cash. I'm going to give you this water bottle. But it's totally fine because this water bottle is every bit as good as the folder that I'm taking from you. Who decides the truthfulness of my claim that this water bottle is an adequate substitute for the folder I'm taking?
If there was a dispute, I believe that would be an issue for the jury, Your Honor. It's a factual question as to what is the substitute. But I just want to impress that is not the question presented in this case.
Is there a dispute of fact on that in this case? If the district court's fact finding was correct, that this is one parcel, one project, that substitute facilities is the correct form of compensation, then is there a dispute of fact after that as to the adequacy of the substitute facilities? I didn't see you disputing that in the district court.
No, Your Honor. Again, the question here is not, like you see in most substitute facilities cases, it's, are we going to build a 1-car tunnel or a 2-lane tunnel? Are we going to build it 10 miles long or 5 miles long? In all these cases, there have been, again, these two conditions. You can't determine the fair market value of the property, or the parties have agreed that it's going to be a substitute facility. In every case,
that's your argument of there's a sentence in Duncanville that strikes me as a real problem for that argument, though. What do you do with the statement in Duncanville where the Supreme Court just flat out says the United States could have provided a substitute instead of cash? It doesn't qualify that. It doesn't say only a fair market value. There's a flat out statement by the U.S. Supreme Court that said that's probably dicta in the context of that case. But what do I do with that sentence?
Your Honor, with respectfully, I don't believe that's what that sentence says. What the sentence says is that Brown, it talks about Brown, the Supreme Court case, and it says that Brown could be read to allow, and again, I have it in my brief and I don't have it, I can pull it up if you give me a moment. But essentially what they said is that Brown could be read to allow substitute facilities to be a constitutional form of just compensation. But what Duncanville found in that case was that, and every other case that has looked at it since, including cases that the United States cites, including that Peace Arch case, it says that substitute facilities is an appropriate form of just compensation when you cannot determine the fair market value. It's fair market value is not going to make the condemnee whole. It is a protection for the condemnee. It is not a weapon for the United States to unilaterally declare that fair market value is no longer an issue in this case. Again, it's not that the United States is that we're not going to get any money. We're not even going to have a trial about what the market value. It just comes off the table as soon as the United States declares substitute facilities.
Synthesize
Sure.
questions and answers from my colleagues that you've made under the rule, which admittedly is kind of an unusual prospect of allocating the authority between the trial judge and the jury. The trial judge has more exclusive authority than he would in the ordinary jury trial. So these initial two issues of whether or not a singular taking has occurred and is the substitute facilities theory just compensation would seem to me to be within the province only of the trial judge. Do you agree with that?
I don't necessarily agree with that, Your Honor, but I think the more fundamental point is that the district court applied the wrong test. The district court proceeded that, let's just say it's one taking. I mean, we would disagree factually that it's one taking. We think the history of this project and the history of negotiations clearly show.
Disagree factually.
Disagree factually. Right. That is one project.
Is there any authority or anything that we look to that says anything that requires us to find that the district court was wrong, right? If it's a fact finding the district court makes, she has to be clearly erroneous, but there's no sort of legal standard that the district court's finding didn't live up to here.
I would say that the district court basically rewrote takings law by stating that fair market value comes off for anything included in a taking if any aspect of that taking is being compensated by a substitute facility. And so again, I don't think it's one taking, but because the United States put it together, despite having agreement on Columbia Pike, condemned it all at once, it's one piece touches substitute facilities, the whole taking and just compensation is contaminated.
Third question, which is the substitute facilities, which would appear the trial court was the proper body to make that call. Is that just compensation? And I think the test in that circumstance is what you've received the functional equivalent of the properties taken. So I know the opposing counsel states in their brief that there isn't any dispute that the road network will have at least the same functional utility as the road network that was taken. And I'm not remembering right off that you ever argued or proffered evidence that that was incorrect.
Yes, Your Honor, but it's the premise for the Keiko Road network. The United States took the Southgate parcel, which is valuable property that their own appraiser agrees is available for residential development. They stipulate has fair market value. The county produced residential development scenarios for the parcel, unrefuted expert testimony supporting such development, and numerous examples of approved rezonings of the same zoned property within Arlington County. It's used as a road today. Nobody doubts that, but that doesn't define the highest and best use of this property. And the district court didn't address any of that evidence or any of the law in characterizing this property and granting summary judgment. The district court just said it's a road, just like Columbia Pike. And because one is a substitute facility, we're just going to deem the whole thing a substitute facility. That is new law, Your Honor.
Thank you very much. You've got some time left on rebuttal, Mr. Brabender.
Thank you. My name is Alan Brabender, and I represent the United States. The United States took a road network from Arlington County, and it is providing Arlington County with a new and improved road network that has at least the same functional utility as the taken road network. And as the district court found, the new road network provides compensation through substitute facilities.
Counsel, if they had ever contested whether or not the new road network had the same functional utility as the existing road network. Is it your understanding that they did or did not contest that proposition?
The county does not contest that proposition. In fact, the county board has unanimously approved an ordinance or a resolution agreeing that the road network is at least the same. They don't use the same functional utility test, but they agreed that they like the road network.
Can I just ask you, you move for summary judgment, and then I read a district court order, and the district court says over and over, I find. And at this point, but there is nothing about granting summary judgment in these actions. And so I'll just tell you what my fundamental problem is. If this is a Rule 56 proceeding, if this is an actual summary judgment, actual findings at summary judgment, and if this is a Rule 71.1 motion, I don't know what the basis of doing a summary judgment motion is. I completely agree that district court gets to make procedural morass. I am very confused about how this is happening.
Okay, so at the outset of this case,
I read what motion is that?
It was a general motion, I guess, under the rules, Your Honor.
Okay.
Can I ask just to clarify, do you agree with Judge Hyten's premise that the rules of civil procedure don't apply except for 71.1? I thought we had precedent that said unless they're in conflict with, they apply unless there's a conflict between the rules and 71.1. But it's been a while since I looked at that.
That sounds right, Your Honor.
Thank you.
Okay, but if that's right, if it is a Rule 56 motion, do you agree that district courts don't get to resolve disputed issues of material fact at a summary judgment motion?
A summary judgment question, but there are also evidentiary questions. At the very start of the hearing, Judge Brinkma said, I'm here to hear argument and take evidence. And so it was maybe a dual function. You could look at it as a dual function type of hearing. And so the court went on to resolve this sort of factual dispute. And then based on that resolution.
A hearing on the merits and a Rule 56 hearing together? This is sort of an odd duck.
It is a very odd duck. It's because condemnation proceedings are different than the typical civil proceedings. But in condemnation proceedings under the United States versus Reynolds and under 71.1, it's the district judge that makes all the factual determinations other than the amount of just compensation. That's true in cases
involving a bench trial too. I mean, you can have a civil case, just putting aside this, you can have a regular old civil case that's going to court is the ultimate fact finder. Does not mean that the court can resolve genuine issues of material fact at summary judgment, right? That doesn't the fact that the court ultimately is the finder of fact does not mean that the court can make findings of fact on a Rule 56 motion, right?
Well, again, I don't think you have to view everything that the district court judge did as under Rule 56. I think you could look at it as under Rule 56.
I'm sorry. Am I right that you were the ones who filed for summary judgment under Rule 56? You didn't file a motion for judgment as a matter of law or to have an evidentiary hearing or a trial on the merits or whatever the heck you'd call this. You were the ones who said, we move for relief under Rule 56.
I believe that is true. And to the extent we cited only 56, I think, the judge could have still sponte ruled under 71.1. But the fact of the matter is the district court did make fact findings, and we think those fact findings are owed deference. There's no reason to say. One case
of this court where we said that where we upheld a district court judgment that made factual findings on a summary judgment motion?
I believe the International Bancorp case is one case, Your Honor.
Can I ask you a different question? So this whole when and whether the government can do substitute facilities, and I understand your argument is we can do them whenever we want, And I understand their argument to be you can only do them under these certain circumstances. I looked and I couldn't find one, but please could you tell me, do you know of any case where a court has said that the government could give substitute facilities instead of cash over the objection of a landowner who says, no, 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 I want cash? I wasn't able to find a case. I mean, I know there are cases that say you can sometimes give substitute facilities, but I haven't been able to find a case from the Supreme Court or this court saying where the landowner says, no, 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 that's cool. Don't want substitute facilities. I'd really prefer the cash, however fair market value comes out. And where the government says, no, you're going to take substitute facilities. I wasn't able to find a case where that happened. Are you aware of one?
I am, and it's not a Supreme Court case. It's not a Fourth Circuit case, but it's a Sixth Circuit case. It's Jefferson County versus Tennessee Valley Authority, where the county in that case, just like the county here, wanted cash, but the Tennessee Valley Authority provided substitute facilities, and the Sixth Circuit found that the county was therefore not entitled to cash because the substitute facilities had been provided. And although this isn't a substitute facilities case, the Supreme Court case of Blanchette, I think, is relevant because there the government provided stock in a new corporation, even though the creditors of the bankrupt railroads didn't want stock in an unproven corporation. They wanted cash. But
do you think the government could do that to a private landowner? Do you think the government could say to a private landowner, I'm going to take your real property? And I know you don't want me to take your real property, but unfortunately for you, we just can do that. And I know that you'd rather have cash, but I'm going to take your house and I'm just going to give you another house. But the good news for you is that the house I'm giving you is just as good as the house I just took. Do you think the government could do that to a private landowner?
Yes, and that's exactly what happened in the Brown versus United States case, where the form of the compensation was to relocate the town somewhere else.
No, but yes, I agree with you that it looks a little bit like Brown, but the people who were objecting in Brown were not the people who lost house one, right? The people who were objecting in Brown were the people whose houses were being taken to be given to the people who lost. And I don't read Brown as very helpful for you because to me, Brown is not a case where the person who's actually having their stuff taken by the government in the first instance is saying, I read Brown as saying the people in town one are perfectly happy to move to town two. It's the people in town two who are unhappy about it. Isn't that right?
Yes, Your Honor, that is correct. And I think the ultimate question, though, in
fact, a lot of people would be very surprised to learn that you think the government can take my house and not only not give me cash, they can tell me I have to take some other house.
Right, and the ultimate question, of course, would be for the court to resolve whether or not that did make the landowner whole. And I doubt there's a situation where the government would want to do that very often, because oftentimes substitute facilities are more expensive than just cash compensation. But as a strict matter of law, I think the government probably does have that authority. And here, the county contends that this is sort of a unilateral decision to impose substitute facilities, but that's not what happened. The county wants substitute facilities. The county needs substitute facilities because Columbia Pike is so important to the county's road network. It's the main street in the southern part of the county. More buses travel on as the National Landing, which is where Amazon is locating its headquarters. So the county would have suffered a dramatic but for Southgate Road as well to make up for the closing of Southgate Road, because the theory was that the closing of Southgate Road, which is parallel to Columbia Pike, will cause additional traffic to build a 75-foot width, but at Columbia Pike to 88 feet. The county wanted bicycle facilities on Columbia Pike to make up for the loss of bicycle facilities and
the ultimate finder of fact.
I think it would be a question for the ultimate finder of fact. It is similar to the determination of the amount of just compensation, the adequacy of the just compensation.
Right, but then why doesn't that mean that you lose here? Because the district court did it here.
No, because the county conceded that the road network is at least the functional utility, has at least the same functional utility as the taken road network. That's why there's no genuine dispute of material fact. Because the county is
what we're taking, and they say, well, no, it's not for the following 5. You think that is something that the district court wouldn't resolve? That would go to whoever this.
That would go to the jury or the commission. Sure. Yeah.
Okay.
That's correct.
So What's your basis to say that the county has conceded that point? And I take it the argument, if that's correct, then even though in theory that's a question that goes to the jury, here there wouldn't be anything to go to a jury. It's in effect abandoned or waived by the other party.
Well, the county doesn't dispute it in their brief, for one. And as I mentioned at the beginning of the argument, the county board has adopted a resolution that approves of the substitute road network.
I thought, and when I asked your friend on the other side if there was a dispute of material fact about the adequacy of the substitute facilities, and he said there was not. If the district court was right that this is one project, one roadway, one connected taking, and if the district court was right that substitute facilities are the correct mode, I believe he said, if those two are correct, then there is no dispute of material fact about the adequacy of the compensation. But we can ask again on I'm getting a nod, but I won't hold you to it. I'll let you say again. But I because I was concerned about this, and so I asked that question, and I believe the answer is if we get through those two things, then there is no dispute of material fact. And so that's your concession that you just referred to. Correct.
It's the condemn or with Arlington County's additional questions.
Yeah, well, your friend on the other side talks about how both parties agree that the deed restrictions by an expert, putting a dollar number on that. So what do we do with that in trying to assess the determination that compensation shouldn't be paid in cash?
Well, when the form of the compensation is substitute facilities, the fair market value just isn't relevant. Fair market value and substitute facilities are mutually exclusive forms of compensation.
So the argument is if something has a fair market value, then you can't use substitute facilities is the argument that's being made. What's your response to that?
Well, that's not the law, would be our response to that. In Duncanville, for instance, the landfill at issue had a fair market value. And yet the Supreme Court said the United States could have provided a substitute facility if it wanted to.
What do you say to your friend on the other side's argument that you're weaponizing a doctrine that is designed to protect the county to then use it against the county? I mean, their take, which seems plausible to me, is the reason we allow substitute facilities sometimes is to protect a landowner whose thing that was taken has a fair market value that is either low or, I guess we'd probably now say with sort of modern economic analysis, we'd say is extraordinarily difficult to assess. There are some property, because I think economists would tell us all land has some fair market value, but there are some situations where it's extraordinarily hard to determine what the fair market value is. And so the substitute facilities doctrine steps in there to protect the landowner because you'd say the fair market value is $5. And they'd say, but I have a road there. And surely when you take my road, you've harmed me more than $5. And so that steps in to protect the landowner. And that in this case, what the government is, according to them doing, is coming over the top and taking a doctrine that was designed to protect them and making them far worse off by saying, look, I know there are experts who say this parcel is worth millions of dollars in fair market value, but it's only got a road on it right now. So we'll just build you a new road. Even though that actually leaves them with less. So, I mean, sort of what do you say to that overall response that you're essentially trying to take a doctrine designed to protect a landowner and then asserting that the government can then use that doctrine against the landowner to make the landowner worse off?
I would say that the provision of substitute facilities here is protecting the landowner. Arlington County needed substitute facilities. It would have suffered a devastating loss if the United States had just simply taken the land and paid cash.
So this is the federal government knows better than Arlington what's best for Arlington? Is that some version of that?
No, because Arlington wanted the substitute facilities. And they wanted the substitute facilities not just for Columbia Pike, but for Southgate Road as well. They wanted the wider Columbia Pike. They wanted the access road. They wanted the bicycle facilities. They wanted the parking garage, or at least they're getting a parking garage. So they're getting what they asked for. By asking for cash as well, they're seeking double compensation, which is improper under the Fifth Amendment. And again, unless the court has any other questions, would ask that the judgment be affirmed.
Thank you very much. Mr. Auslander, you've got some time in rebuttal.
Thank you, Your Honor. This is to answer. I'm sorry, apologies.
It's up to you.
Yep. Can't forget it's on these days. To answer Judge Rushing's question, if the question in this case is whether there are adequate substitute facilities, that's not the dispute in this case. And the district court thought that that's where it began and ended, and that that's just not the question here. Again, the government believes it took a road network and it's giving a new road network, but that's not the facts. And I think the question about who decides really is the key here, because the county was not.
Your underlying issue is the district court was wrong to find it was a singular taking.
No, Your Honor, because I believe the court was wrong to find there was a singular taking, but the court was also wrong to find that the singular taking means that anything taken within that singular taking has to be compensated by substitute facilities. And the fair market value that is clearly stipulated for some of that property suddenly goes away because the government decides that it's going to include the Columbia Pike piece too. The government Mr. Brabender spoke to land. It's not land that we agreed that needed to be substituted. It's the Columbia Pike piece. No one ever proposed to close down Columbia Pike. It's one of the biggest arterials in the middle of Arlington County. But that is not true for Southgate Road. Southgate Road is an access road to a federal military base that the county could live without. The government built it for itself to access a federal military base. And
there was quite a bit of testimony that if there wasn't Southgate Road and you didn't have South Nash to replace it, that it would be havoc on the neighborhood right there by the base gate.
I wouldn't say there's havoc, Your Honor, but the government was going to close the gates. The government necessitated base access. The government needed base access. And so it's creating itself new base access and not all of the new traffic is going to use South Nash. Some of it's going to access the base by other means. I just want to point out in my very limited time, sorry, apologies. Yes.
If we were to determine that the district court, we're just assuming this, the district court was correct to decide there was a singular taking. It was correct to decide that that the substitute facilities theory is appropriate in this case. Then the question that would be left for the jury in theory is whether the actual substitute facilities were functionally equivalent as just compensation. And what I understood your answer to Judge Rushing's question to be was that that's not something you can test.
That is correct, Your Honor. There would be no jury trial.
There would be no question.
Correct, Your Honor. The final judgment in this case, stated that the substitute facilities doctrine applies, that the receipt of the new realigned Columbia Pike and the realigned Southgate Road constitutes adequate just compensation, and the case is closed. And so affirmance of summary judgment would effectively end the case. Again, this is not about the adequacy of substitute facilities like is in every other substitute facilities case. But just again, the judge is wrong. The district court was wrong because it creates brand new law. There is no case, not one, that says that even if it's one project or one taking, that it's one form of just compensation at all. There's no case that says that. There's also no case where the United States alone could decline payment of fair market value, where the United States gets to choose that unilaterally. No case, but this court allowed that to occur. There's also no case where a district court found in the face of competing expert appraisals for the taking property that there was no material issue, disputed issue of fact. We have two expert appraisals here. We have evidence on both sides, but again, the district court on summary judgment is not a function of weighing the various evidence. This court has been clear that when there is a summary judgment motion, it does not get the deference that a full trial record would get. The government misstates the standard of review in its brief. Your Honor asked earlier whether the county thought that Columbia Pike was just compensation for Southgate Road. Again, I will point out Columbia Pike's width, features, what have you, would be the same with or without the closure of Southgate the closure of Southgate Road and the taking of the Southgate parcel. That's what the record shows. Government doesn't contest any differently. What the compensation for the Southgate parcel was going to be going all the way back to 2008, and this is in the 2008 memorandum of agreement and the 2013 memorandum of agreement, is there going to be substantial federal acreage, not just South Nash Street, not the realigned Columbia Pike, but there was going to be substantial acreage south of Columbia Pike that the United States was going to give to the county specifically to get the Southgate parcel. Then when 2017 came around, the United States walked away from that and said, it's still going to be just compensation. We're just not going to give you that land, and we're not going to give you any money either. It's just the project. The project now itself is just compensation. That change in course was a total surprise to the county. And it matters not just for this case, but for future cases as well, because the whole point of the Uniform Relocation Act and is to have discussions, do appraisals to avoid the need to condemn property through litigation. And the United States took the opposite course here. We reached agreement on Columbia Pike, as that would be a realignment, basically a one-for-one, road for road. And then the United States is leaning on that in order to avoid paying monetary just compensation for the undisputably valuable Southgate development parcel. And that is, it would have significant consequences for future condonees by allowing the United States to dictate what's just compensation rather than the court. There's no further questions. I'll yield the remainder of my time.
Thank you very much.
Thank you.
The court appreciates the very able argument of counsel on both sides. And ordinarily we come down and greet counsel in person, but that's still not an option for us. So I hope the next time you're back that the rules will have changed and we'll be able to do that. So I'll ask the clerk to call a short recess.
Villegas, Your Honor.
Villegas, we'll be glad to hear from you.
Thank you, Your Honors. Good afternoon. Carol Villegas from Labaton Sucharo for plaintiff appellants. This is an appeal from the district court dismissal with prejudice of a securities class action fraud complaint. The issues before the court today are whether defendants made false or misleading statements with the requisite level of scienter and whether plaintiffs have adequately pleaded loss causation. I'm going to start with the false statements, but before I do, I just want to put this case into a bit of context because the securities laws require the court to view these statements, all of the statements that were made, in the context in which they were made. We've all heard of Marriott. Many of us have stayed at Marriott's, and we all know it's a big hotel company. In the face of competition, Marriott decided to purchase Starwood, another big hotel company. This was the largest hotel merger in history, worth $13 billion. And in purchasing Starwood, Marriott just wasn't purchasing the operations, it was purchasing data about Starwood's clientele. These were usually business travelers who like to spend money. And so this was very important for Marriott's growth. Defendant Sorensen described the merger as a bet on Starwood's loyalty program. And the market recognized that Marriott purchasing Starwood's valuable customer data was a main driver of this massive merger. Now, what we've alleged in the complaint is that there were a lot of problems with the way Starwood housed this extremely important data. We have employees from both Starwood operations and Marriott operations, as well as reports that were actually commissioned by defendants and presented to the board and to the defendants that tell us that Starwood's IT systems didn't just have minor problems, but the problems were so significant and so widespread that the Starwood data was extremely vulnerable to a cyber attack. I just want to give you a couple of examples of how bad the situation really was at Starwood. They were using software that was 7 years past the end of its life. This Oracle portal could no longer be patched, meaning it could no longer accept system upgrades, which led it to be very vulnerable to attack. Passwords were not encrypted. And Starwood was also failing to analyze log data. This is a very basic cybersecurity measure where you can see if anyone is infiltrating the system, and you would have to monitor those logs to determine if that was happening. Now, Starwood and Marriott are both credit card processors, and as such, they needed to comply with the payment card industry or PCI regulations. You're going to hear us talking a lot about PCI today. We know based on the confidential witnesses I mentioned and those same reports commissioned by the defendants and provided to defendants and the board that Starwood was not complying with a number of these very important PCI regulations. At the end of the class period, as we know, Marriott announced a massive data breach, one of the largest in history, affecting 300 million of its customers, and the stock price dropped by 5%. So with that in mind, I want to turn to the first set of false statements, which is the risk language, which the company made in its Form 10Ks and 10Qs. Defendants said, among other things, the information security and privacy requirements imposed by governmental regulation and the requirements of the payment card industry, so the PCI requirements, are increasingly demanding. Our systems may not be able to satisfy these changing requirements. We allege these statements were false and misleading because even though Marriott is saying that they may not be able to satisfy the payment card industry requirements, at the time the statement was made, Starwood systems that Marriott purchased were absolutely not in compliance.
What do you say Marriott should have said?
Well, Your Honor, they had a choice. They either could have said nothing at all about the PCI compliance, or they could have told the market that they're working to upgrade Starwood systems so that they can better protect the information that they purchased in the merger, which would have been a truthful statement.
So how would that have informed an investor?
Well, I think, Your Honor, that
working on the Starwood system?
I think, Your Honor, that it would have informed the investor that the Starwood systems may not necessarily be up to par. They could have also told the market that they were working to alleviate certain vulnerabilities in the Starwood system as well. Or they could have said nothing.
If you did that, seems like to me that would be like taking an ad on the internet to every hacker in Eastern Europe and the Soviet Union and elsewhere around the world to come on in.
Well, Your Honor, it was their choice, so they didn't have to even mention PCI compliance. But when they did, then they had a duty to tell the market at that point that it wasn't that they may not be in compliance, but they actually weren't. I mean, those are the words that they chose, PCI compliance. And we have the reports that show that they actually were not compliant with PCI at that time.
You say that they have a choice, and of course they do select the language, but we're talking about the risk disclosures, and that the SEC, my understanding, requires risk disclosures of these are things that are risks for our company. And the concern, I think, is that for every time a company tries to comply with those risk disclosures by saying, you know, we may not be able to do this or that, if some future event happens, it could have an adverse impact, that they then have to make a corresponding statement about whether they are actually, you know, how that's going today. But that investors don't actually read risk requirements to warrant today everything's A-okay with this particular issue that we're talking about.
Yeah, so I think in this particular case, you have to look at the context of the statement and why an investor would care, partly because of what I mentioned before, which is that the merger, the $13 billion merger, was really a purchase of this customer data. And I think it would have been significant to an investor to know whether that data was secure or not secure.
But I guess my point is, you're saying investors read the required risk disclosures, not just as the risk disclosures we may not be able to keep up, that an investor reads that to say, today we are totally in compliance.
I think the issue is that we may not be able to keep up is a little bit different than we may not be compliant with PCI standards today. And in this particular case, it wasn't that there were just issues with the software or that they needed to patch little things. It was that the problem was so large and so widespread, and they had actual notice that they weren't compliant with PCI. So I think that that's what really makes the statement false, because to say that they may not be in compliance when they really weren't in compliance.
Can we stick on that statement, the first one you've identified? Are you saying that that statement is false, or are you saying that it's misleading?
It's misleading by omission, Your Honor.
Okay, so the actual statement is not false.
Well, no, I think the statement could be seen as false also, because we may not be in compliance when you're actually not in compliance is not actually telling the whole truth about compliance with PCI standards.
So how do you correct that without saying, let me give you a laundry list of all the things that aren't right. So 24 hours from now, we'll be hacked by everybody.
Well, the alternative, Your Honor, is they could have fixed the systems, which they didn't do. We have pled in the complaint that...
Isn't that part of the disclosures? They say we may not be able to satisfy these changing requirements or may require significant additional investments in order to do so. So they're saying we may have to make some changes to satisfy these requirements.
Right, but I guess the point is that when we talk about the reports that the board commissioned and that the board was provided, the types of problems that they were seeing in these reports starting in 2016 and going through 2018 were the same exact problems. They weren't fixing them. So, you know, they could have either fixed them, or they could have said nothing specific about PCI compliance, or they could have told the market, you know, our systems or the Starwood systems that we purchased need some upgrades and we're making them, or something to that effect.
And so you think an investor is going to adjust what they're willing to pay for stock in Marriott, or decide to sell Marriott stock because there's a disclosure that we may have to fix an information system somewhere?
In this particular case, Your Honor, I do, only because that specific data was so important to the merger and so important to the valuation of Marriott when they merged the two companies. So for an investor to know that this information might not be secure, I think that's important, because when the information isn't secure, you have these...
Told them that it might not be secure several places.
Well, they didn't say it wasn't secure, which is what the truth was. So
I ask you to respond to what strikes me as the challenge of your argument, or in my head at least. I mean, I'm willing to totally accept that the actual IT situation at Marriott was bad. And I'm totally willing to accept that a reasonable investor would be very, very interested in knowing that the IT situation at Marriott was bad. But the problem, it strikes me, is that the securities law don't have a blanket requirement that you have to tell investors every single thing they want to know, including things that are bad. It's only, you can't make a false or misleading statement. And I guess, could you identify for me what you think is your single strong, because my difficulty is that a lot of their statements strike me as at least literally true. And so could you identify what you think is your strongest statement for a statement that when made was false or materially misleading?
So I guess I have two things to say to that. The first is that even a literally true statement could be false and misleading by omission. For the risk language, I think it's really that they may not be in compliance with the PCI regulations when they weren't. And I would point this court to the Alphabet decision in the Ninth Circuit, which we cited to in our brief, which looked at risk language that actually wasn't even as detailed as this, and found that risk language was false and misleading in the face of defendants commissioning reports and receiving reports. And they found that the omission of any mention of the security vulnerabilities made that risk language misleading. And so I want to turn.
What about this language? Our business may suffer if we fail to maintain, upgrade, or prevent disruption to our reservation system. It could increase in connection with the system integration. Disruptions could result in a disruption to our business or the loss of important data. That all seems to be true, and it also seems to say that if there are any defects, they could be a big problem. Why isn't that sufficient to alert an investor if that's something they're concerned about?
Well, Your Honor, because there were defects. It wasn't, there may be defects. If there are defects, there actually were defects at the time. And so
that kind of goes back to the previous questions I've asked you. I'm still not sure how you anticipate in this circumstance that the disclosing party is supposed to meet your view of what's adequately disclosed without broadcasting to the world, which the SEC says it doesn't have to do, what the defects are.
So I think, Your Honor, it's simply that, the risk disclosure didn't provide investors with the information that the company knew about the issue. And, whether that's going to open them up to, investigation by a government organization or cyber hacks. I mean, it's on the company to remedy these issues. Investors are purchasing the Marriott stock because they know that this $13 billion merger is going to be accretive to the company. And if there's something wrong with what they're purchasing, whether it's a good, a service, or data, investors have the right to know about that, especially when they specifically call out the PCI compliance and they're not PCI compliant.
Thank you very much, counsel. You've got some time left on rebuttal. Mr. Mindro, should give us your side.
Good afternoon, and may it please the court. I'm Jason Mendro. I'm here today on behalf of Marriott and the individual defendants. The fundamental problem with this case is that every one of the statements that the plaintiff challenges is 100% true. The complaint, the appellant's briefs amount to little more than a litany of supposed cybersecurity issues, followed by a cursory rebuttal of statements that the defendants didn't make. That is not securities fraud. In Phillips versus LCI, this court made clear that the role of courts in securities litigation is to strip the mischaracterizations and exaggerations from complaints and examine the exact statements that the defendants made in their true context. While performing that exercise here makes clear that there are no actionable statements. Most of what the court just heard, and I think is consistent with the briefs, most of what the plaintiffs challenge are Marriott's warnings. These aren't assurances, but these are warnings to the market about reasons why an investment in Marriott stock is risky. And Judge Rushing is right. Marriott doesn't have a choice about issuing those warnings. It's required to do so by the SEC. This is item 105 of Regulation SK, which requires companies to identify the material factors that make an investment in their stock risky and to concisely explain those factors. That comes directly from the regulation, concisely explain. Companies are not required to disparage their cybersecurity. They're not required to detail vulnerabilities. They're required to identify material factors and explain them concisely. The statement that Marriott may not be able to satisfy changing requirements of the payment card industry is a warning. It's not an assurance. And it's true. The statement that Marriott believes that the integrity and protection of its data is critically important, it's true. You don't have to take my word for it. Page 4 of the appellant's brief says that Marriott's data is critically important and that Marriott acknowledges that. So it seems that we're in agreement. The warning that Marriott could be affected by cyber attacks is true. It's the reason that we're here. Marriott explains that cyber attacks could have a disruptive effect on its business. And importantly, when Marriott detected the attack that's the subject of this case, it changed its risk warnings. It changed them to say that we have experienced cyber attacks in the past tense. And that makes this case the complete opposite of the case that Ms. Villegas just cited from the Ninth Circuit concerning Alphabet. In the Alphabet case, the Ninth Circuit found that risk factor disclosures were misleading for one reason and one reason only. It's because the company affirmatively said that its risk had not changed since 2017, just after its management learned that it was subject to a new risk that it didn't disclose. Here, Marriott didn't do that. It didn't make any affirmative representation that its risk didn't change. It changed its risk factors to reflect its understanding that there's been a new event and its
Do you
risk
think
had
it would have
changed.
been misleading if you hadn't done that? So you just represented that we didn't know, and once we found out it had happened, we changed it to say that it had happened. What if they never changed it? Do you think that would have been false or misleading?
I don't, Judge Heitens. I think that the statement that we could be, where the cyber attacks could have a disruptive effect on our business would have been just as true if the company didn't add that we'd been subject to cyber attacks. And that is the fundamental question. As you correctly pointed out, Judge Heitens, in securities law, there is no obligation to say anything that an investor might hear. That's been true since Basic v. Levinson. The Supreme Court repeated it in Justice Ginsburg's decision. Well, it was in Matrix. This court has repeated that point continuously. The obligation to speak only occurs when your affirmative statement is misleading. So the affirmative statement that we may be subject to cyber attacks that could have a disruptive effect on our business would not have been misleading even if there had been a cyber
What about
attack.
the statement that we may not be able to keep up? Another statement that was made, right? We may not be able to keep up. I mean, I guess I would say it doesn't strike me as totally implausible to say if a person told me I may not be able to keep up with something in the future, can at least arguably be read as suggesting that I am currently keeping up, right? So if I say I may not be able to keep up in the future, it's at least plausible to think that what I'm saying is I am currently keeping up now, but that may change in the future. And so, you know, when Marriott said we may not be able to keep up, how isn't that at least difficult to square with the fact that they were already failing to keep up?
For two reasons, Judge Heitens. Number one, I would submit that saying that we may not be able to keep up with PCI standards is not a representation that we're currently complying with those standards. It's a warning that perhaps we're not. And several cases have made clear that a warning is not misleading just by virtue of the fact that you haven't disclosed something that's going on currently. That was basically the rationale of the Sixth Circuit decision in Bondali versus Yum Brands, in In-Ray Channel Advisors, the Eastern District of New York, or Eastern District of North Carolina, I apologize, used the same rationale, and this court had no trouble summarily affirming the decision to dismiss in that case. So that's point number one. But point number two is the rhetoric in the complaint about the defendant's knowledge about not complying with PCI standards does not match the allegations of fact. The allegations of fact do not plead specific factual allegations that the defendants were aware that the company wasn't complying with PCI standards. What the specific allegations of fact plead is that the board of directors was very focused on this issue. It got attention from the highest levels of management. This can be mostly found at paragraphs 314, 315, and 316 of the complaint. That the board of directors heard a presentation from an outside expert at PwC, making recommendations about how to improve cybersecurity, including by mandating PCI compliance. That doesn't mean that there was any findings of a violation. The complaint goes on to incorporate by reference a slide from that presentation that makes clear that management's intended actions presented to the board were to improve cybersecurity at Starwood and to hire yet another consultant to conduct penetration tests. That consultant was called Protiviti. The purpose of a penetration test is to identify weaknesses, find holes, and plug them. And the complaint goes on to allege specifically that Marriott did hire Protiviti and that Protiviti did conduct penetration tests. That's at paragraphs 28, 222, 223, and 609. And paragraph 316 of the complaint makes clear that when the board convened again a year later at its next annual risk assessment, it heard from management about its progress. And it learned at that time that Marriott was transferring Starwood's technology standards and security standards to Marriott's. And in the meantime, the company was patching Starwood's system. So what the board actually heard is that the company was working on this issue. It did not hear that the company was in material noncompliance. And the simple assertions that Marriott did nothing or plain rhetoric that just simply are not supported by the allegations of fact. And when we pointed that out in our answering brief before this court, in reply on page 12, the plaintiffs acknowledged that Marriott actually did contemplate fixes. They just go on to say that those fixes were not good enough and not fast enough. So what this basically devolves into is a dispute about whether Marriott was satisfying whatever standards the plaintiffs have for how fast these data security issues need to be addressed. But there's nothing in the complaint that would support a conclusion under the strict standards of the PSLRA that the statement that we may not be able to comply with PCI standards or other standards was in the least bit false or misleading. The other statements the plaintiff challenges are online statements. These are statements that are made to hotel guests, and these are also warnings. They're statements that caution guests that although the company will try to protect their private information, it can make no guarantees. Both of Marriott's statements in the complaint say that no transmission of data or storage on system can be 100% guaranteed to be secure. And Starwood's, when Starwood had a separate disclosure, Starwood's statement said that guaranteed security does not exist either on or off the internet. These statements could not have convinced any reasonable person that their data was impervious to attack. They could not have convinced any reasonable person that Marriott could not be subject to cyber attack, and they are truthful. Importantly, they also have no effect on investors because these are statements that were not made to investors. They were not made in SEC filings. They were not discussed at investor conferences. They were not discussed by investment analysts. So they're not made in connection with the purchase or sale of securities. Even if the plaintiffs had alleged any false or misleading statement, and I submit to you that they did not, the complaint falls far short of the PSLRA's obligations to plead scienter. All of the scienter allegations in the complaint are pure misdirection because they don't concern misleading investors. They're simply a list of securities risks that the defendants didn't deny or mischaracterize or even discuss with investors. And the plaintiff is wrong to argue, as it did on pages 31 and 32 of its brief, its opening brief, that scienter allegations don't have to be about deceiving investors. They do. That's the central focus of the scienter inquiry, is whether the defendants deliberately or recklessly deceived investors. This court has made that clear many times in McGuire, in the Deloitte and Touche case, in the Hunter case, and Judge Agee's decision dissenting in Singer. None of the allegations concern deceiving investors. They only concern what the defendant supposedly knew about assorted cybersecurity risks, which may or may not have had anything to do with the breach that eventually occurred. It's hard to know, in the absence of any false or misleading statement, to point to what the guilty knowledge would be, because the only thing that is relevant as guilty knowledge under the securities laws is knowledge of misleading investors. But even if it were true, as the plaintiffs incorrectly argue, that knowledge of some kind of urgent security risk would give rise to scienter under the securities laws, the complaint doesn't satisfy that standard with particularity. What the complaint really pleads is disagreements among certain confidential witnesses, only one of whom ever spoke to any of the defendants. That defendant is no longer alleged to have made any false or misleading statement that the plaintiffs challenge on appeal. And simple disagreements about business matters don't give rise to fraud. They don't give rise to scienter. That was the reasoning in KBC versus DXC, which we just submitted as a supplemental authority. It was also the reasoning of this court's decision in Triangle Capital. What the allegations show, again, is that the board placed a high level of importance on this issue, received regular updates, authorized the company to retain leading experts who conducted tests, who upgraded the systems and patched Starwood while the upgrades were occurring. Those are not allegations of fraud. Those are not allegations of misconduct. Those are allegations of a responsible company doing what it could in a difficult circumstance. And the allegations at paragraph 259, I think, are also quite instructive. At 259 of the complaint, the plaintiff pleads that on November 19 of 2018, Marriott learned for the first time that personal information had been exposed by the attack. That personal information was encrypted, meaning that without an encryption code or decryption code, it couldn't be read. Nevertheless, on that very same day, Marriott began the process of notifying affected guests. That is a responsible company making hard decisions under a difficult circumstance. The plaintiff is also incorrect to argue that it gets the benefit of all the inferences in the complaint that might support a conclusion of scienter. The securities laws are very clear that that's not the case. In Tell Labs v. Maker, which is a Justice Ginsburg decision, the court made clear that the inferences that flow from the allegations have to be balanced. It's a comparative exercise. And the court's responsibility is to decide whether the inferences of guilt are at least as compelling as the inferences of innocence. If they're not, the inferences in favor of guilt must be rejected. In this case, the inferences of innocence are overwhelming. Marriott repeatedly disclosed the very risks that are the subject of this case. This court has said on multiple occasions, including in Triangle Capital and KBC, that weighs against the finding of scienter. The plaintiffs failed to plead that the defendants had anything to gain by concealing a breach. This case stands apart from many securities cases because there's no allegation that any of the defendants were selling their securities after they learned about this attack, but before they disclosed it. The allegations make clear that Marriott reported this situation to the FBI and cooperated with law enforcement. Criminals don't call the police. It would make no sense for Marriott to have done that if it was engaged in an exercise to defraud its investors with respect to these issues. All of these allegations point strongly in support of the inference of innocence. In sum, the district court, in a very comprehensive, detailed decision, correctly dismissed this case. Now the plaintiff seeks to rewrite Marriott's warnings as assurances that it never made and to impose vague requirements to catalog vulnerabilities that management discovers that have never been denied. There is no such requirement. Companies would have no idea how to comply with that requirement. As Judge Agee has indicated, such a requirement would actually invite attacks, subjecting companies and their customers and their employees to even greater risks. Those arguments should be rejected and the decision of the district court should be affirmed. Unless the court has any questions.
Thank you very much.
Thank you.
Ms. Villegas, you have some time left on rebuttal.
Thank you, Your Honors. I've given some thought to the question that you asked me before about what Marriott should have said. And one of the things that strikes me is that Marriott could have taken the Starwood reservation system offline and then told the market, we're suffering vulnerabilities in our Starwood system and we're going to fix it. I mean, this was a business decision.
Up to you, counsel, but if you're more comfortable with your mask
Oh,
off.
I forgot, Your Honor. Thank you.
No problem.
And so that's another thing that Marriott could have chosen to do. That's a choice they had. They chose not to, probably because financially they wanted to be getting the reservations through the Starwood system. But the truth is that they knew about the vulnerabilities. They knew that this very valuable information was at risk. And instead of doing something like taking the Starwood reservation system offline to fix it, they kept using it. They actually kept using it even after they discovered that there had been a data breach. So for those 3 months before they told the market.
That may have been a bad idea. That might have, I guess I'm not sure how that's a violation of the securities laws. I mean, that may have been very bad business practice. That may have been something their investors or owners or people who have entrusted their data to Starwood would have really preferred they not do. But I guess how is that how is failure to take it offline a violation of the securities laws?
So we allege that on October 5th, Marriott made statements in its privacy statement, specifically that Starwood-owned websites and servers have security measures in place to help protect your personal data. This is after they learned about the breach. and that the company safeguards your information using appropriate methods, including firewalls and encryption. So they know about the breach. They know that information is very vulnerable. Someone's in the systems, and yet they're making statements to the market that we use all of these, methods to keep your information safe, and we're keeping your information safe. So we allege that that statement was false and misleading because at the time they knew about the breach. They also knew about all the vulnerabilities that existed in the system at the time. The district court found that plaintiffs didn't allege that Marriott failed to use any of the particular security measures that it mentioned. Respectfully, we believe that the district court got this wrong. Confidential witnesses tell us that Starwood wasn't using encryption for passwords. That's paragraph 159. And even though Starwood was using firewalls, it wasn't keeping logs relating to those firewalls, which was a PCI violation. So we think that that makes that statement false and misleading. I know defense counsel mentioned that this was a statement that was made on the website, and therefore it wasn't in connection with the purchase or sale of a security. But we would argue that this is definitely a statement that an investor would rely on, especially given the fact that the data breach had occurred and they didn't know about. If you look at the Equifax case, in that case, there was another statement very similar to the one made here about data security.
Equifax is a district court case.
That's right, Your Honor. And in that case, there was a statement made at a university. It was a commencement speech made by the CEO about how they take pride in data security. And the court found in that case that that satisfied the in connection with requirement because it was very important to investors for a company like Equifax to know that they were actually keeping their data secure and valuable. And for those same reasons, we allege that statements about the integrity and protection of customer data being critical to the business was also false and misleading. The district court found the statements were inactionable puffery, but again, the case law asks us to look at the context in which these statements were made. And given all of these issues that the district court even acknowledged we had adequately pled, we allege that this was also misleading because you can't say something is critical to your business, it's so important to your business, but behind the scenes, you're not protecting it and you're failing to tell the market about it. I just want to turn to Sienter for a moment because I think there's a real disagreement about the standard here. So the standard, we can show Sienter either by direct knowledge or recklessness. And recklessness is sufficiently pled where plaintiffs allege defendants' knowledge of facts or access to information contradicting their public statements. We allege a number of internal reports that told Marriott's board and defendants time and time again that there were issues. These were recurring issues with logging, issues with network segmentation, issues with PCI compliance that occurred starting on July 18th when there was a report detailing these issues. Fast forwarding 6 months to January 2017, PwC talks about the problems with the network segmentation and also that there were extreme vulnerabilities. On February 10th, 2017.
I thought your complaint also recognized that Marriott was at least trying to work on these things.
Well, Your Honor, I believe that after they were notified on February 17th, there was what they called patching. But if you look at the allegations in our complaint, confidential witnesses tell us that the Oracle system could not be patched. That's where the reservation information was held. So if they were patching something, it wasn't the data that we're alleging was critically at risk here. And the allegations of the
even if the confidential witnesses thought that it couldn't be patched, where's the allegation that that was told to any of the defendants and that they knew making the decision to patch was not going to work?
Well, Your Honor, I think if you look at the 4 reports that we mentioned that were commissioned by the defendants and issued throughout the class period, the level of problems that the company had were so severe. The PFI report, which was the postmortem done at the end, actually confirmed that all of the issues that were raised in these reports still existed at the time that they did the postmortem. So none of those very critical issues were fixed. One of the basic issues I mentioned in the very beginning was this issue of logging. It's something that Starwood didn't do. It didn't do it throughout the whole class period, even though those are issues that were raised. And when the PFI report was issued, they said, yes, they're still not logging. So regardless of what the patches were, the problem was so severe and so huge, we allege that these patches could absolutely not be sufficient and that it was still misleading for Marriott to not tell the market about these issues. And I see that I'm running out of time, so I just want to close with a quote from the Second Circuit Meyer v. Jinko Solar case. This is a court cited in the Singer decision. I know, Judge Agee, that you dissented in that decision, but I still think that this is a really great analogy to think about when you think about this case. It's that a company can't disclose in a securities offering a business's peculiar risk of fire, the installation of a comprehensive sprinkler system to reduce fire danger, and then omit the fact that the system has been found to be inoperable without misleading investors. And that's exactly what we have here, which is why we would ask this court to reverse the district court decision. Thank you.
Thank you very much. We appreciate the arguments from both counsel in this case. And as you probably know, in ordinary times, we come down and shake hands with counsel. That's still verboten, at least for the time being. But I hope when you return the next time, we'll be able to resume that tradition. So we'll move on to our next case.
Your Honor.
And it's only up to you. If you want to keep your mask on, you can. If you want to take it off, that's fine too.
Okay, if it's okay with the court, I'll take my mask off. Thank you. May it please the court, Rob Snyder for the appellant, Winston Hensley. The judgment in favor of Fluor should be reversed for two reasons. First, the district court erred when it granted summary judgment to Fluor on its affirmative defense of preemption, despite the presence of disputed issues of material fact. Second, the district court erred when it dismissed Specialist Hensley's breach of contract claim with prejudice. Those are the two issues raised in our briefs. In its response, Fluor also raised the issue of subject matter jurisdiction. So unless the panel would like for me to take the issues in a different order, I'm going to quickly address the court's jurisdictional order and then move on to preemption. The district court entered a detailed order in June 2020, finding that it had subject matter jurisdiction over Specialist Hensley's claims. In doing so, it considered evidence outside of the pleadings, including the Army report, which the district court summarized in a detailed portion of the order, alphabetically from A to close to Z. The district court found in its jurisdictional order that there was no evidence of any formal directives from the Army to Fluor about how it was to supervise its employees in the non-tactical vehicle yard. And it found that Fluor operated with wide latitude and considerable discretion. Because of those factual findings, the district court concluded that the first Taylor factor, plenary control, was not met. The second Taylor factor was not met because under South Carolina's apportionment law, there is no apportionment to non-parties, and the Army is an immune non-party in this situation. So in addition to not being able to apportion fault to the Army under South Carolina law, the jury could never find the Army to be the proximate cause of the specialist's injuries. So the second Taylor factor, whether the court would have to evaluate military decisions, was not met. That order was entered in June 2020. The district court necessarily reaffirmed its jurisdiction over Specialist Hensley's claims in August 2021 when it entered a judgment in favor of Fluor.
So there's some overlap, seems like to me, between this second part of the Taylor test and parts of the Tort Claims Act preemption argument in terms of the courts impinging upon federal interests in terms of military judgments. And part of what we're admonished to do in these cases is we'll look at it as how the case would be tried. So if the defendants in this case, as you present yours, then present a case that says, well, there's contributory negligence here on the part of the Army because of the defective way that they handled the recruitment of this individual, and they didn't disclose that he was part of the Taliban, that sort of thing. Does that have any effect on how we decide either the second part of the political question under Taylor or the Tort Claims Act?
What this court found in the Burn Pit case and what the Third Circuit found in Harris is that if the defendant wants to raise a causation defense, which is what Fluor would do here, that does not implicate the second Taylor factor, because unless the Army is shown to be the cause of the injuries and there's a proportional liability system. So here we're under South Carolina law. The parties agreed when they briefed the jurisdictional issues that South Carolina law governed. And under South Carolina law, you cannot apportion fault to a non-party. So the second Taylor factor is not implicated if there's going to be no apportionment possible to the Army, even if the factual question of what the Army did may be an issue in the case. So for purposes of preemption, all of the evidence that was in the record when the district court ruled that it had jurisdiction over these claims was still in the record a year later. That evidence alone was enough to create a disputed issue of material fact on whether the Army had command authority over Fluor for purposes of the preemption question. We don't dispute that this is a combatant activity under the Fourth Circuit's holding in Burn Pit. The only question that is at issue is whether the Army had command authority.
Can I ask you a factual question, which is what evidence, if any, do you have that Fluor was aware of the bomber's ties to the Taliban?
The evidence that we have of that is Fluor's general knowledge that former Taliban fighters were a part of this reintegration program. And there is some evidence, it's from another case that Fluor tried or was against a different party out in Colorado, that there was seepage between the screening cell that was manned by a Fluor subcontractor and between Fluor management. But the question of whether they knew about his Taliban, and that's what we have. It's disputed whether they knew or should have known of his Taliban ties. Fluor said they did not. We submit there's at least an evidentiary question on that point. But for purposes of preemption, the question is whether the specialist's claims actually implicate the Army's command authority. And the specialist's claims are for negligent supervision and negligent retention. And the record on those claims is exactly what the district court found in June 2020, that Fluor had wide latitude and considerable discretion to determine how it was to supervise its own employees and subcontractors in the non-tactical vehicle yard. The evidence of that is in the Army report, which was based on a detailed and lengthy investigation that followed the bombing. It's in the contract itself. The performance work statement specifically says that Fluor is required to provide the necessary supervision, but there is no further evidence in the record.
Can I ask you about that,
Yes, Your Honor.
the work statement? Because you point that out in your briefs, and Harris and Saleh both talk about the performance work statement. What I'm wondering here is the performance work statement gives Fluor many responsibilities they're being hired to do and says, we want you to accomplish these goals, and they have discretion in how they do them. But this case seems a little different in that we're talking about supervising someone who's a security risk and how that's done. And did the contract give Fluor the requisite discretion in doing that? Or are there these additional requirements like the escort requirement, the badge requirements? It seems like we have to consider those in addition to the performance-based contract, because we're talking about not, did they supervise him as he, in terms of like, was he making enough widgets? But did they follow the military's escort policy that's put in place to protect people from enemy combatants?
Your Honor, we have not alleged that Fluor was obligated to supervise Mr. Nayyab for security purposes. We have alleged that what they failed to do was to supervise him for his work-related purposes, and that failure is what caused the bombing. That's precisely what the Army found in the Army report. The escort policy, which one of the...
I thought you had alleged that part of their negligence, which would seem to go to the security aspect, was that when he was supposed to get on the bus to go to the gate, that he didn't get on the bus and they did not follow procedure at that point. Isn't that a security risk aspect?
It's a security risk in that we know what Mr. Nayyab did, right? We know he committed an intentional act that caused an injury. That Fluor was given the discretion by the Army to figure out how to get their workers onto the bus. If you read the escort policy, it does not apply to the work area. There is no requirement that Fluor escort its employees or subcontractors in the work area.
And they say that they asked the Army, they told the Army, hey, we, for a fee, we'll supervise them, we'll escort them in the work area. And the Army said, no, we can't pay for that. We don't want to do that.
That's the evidence that is in the record, Your Honor. But for purposes of this question, it's undisputed that Fluor had both supervision and escort responsibilities.
But I guess my point is, why isn't that relevant? If, for political question, yes, you have to show, whatever the actual and, almost total control. But when we're talking about preemption, the cases we have seem to, Saleh, for instance, acknowledges that you don't have to have that level of control, that you can have both the military and the contractor with some measure of discretion. But if the military retains ultimate command authority, then we're in the preemption land. That's at least the second factor, right, has been satisfied. So why isn't it relevant that the military is who's making choices about where these people have to be escorted and to what extent they have to be observed and escorted, because they are security risks, not because of, it's important to how they create their widgets?
Well, the inquiry is whether the conduct that's at issue is under the command authority of the military. And what the evidence shows here, at least we contend there's a disputed issue on this, is that the Army did set parameters for escort, but it limited the application of those parameters when the local nationals were in their work area. And in that area, in the Fluor non-tactical vehicle yard, how to supervise their employees, making decisions about whether they should fire somebody for workplace violations, those questions were left to the discretion of Fluor. So it could be that a claim based on a violation of the escort policy could potentially be preempted. But a supervision claim based on Fluor's failure to watch Mr. Nayyab while he was working There's no evidence in the record that the Army ever gave Floor any specific commands.
Isn't that your claim? I mean, the claim you're going to have to prove is that it was negligent because they knew something. Floor knew he was a risk in some way. They knew something and they didn't act accordingly. It was proximately caused here. And that's connected to the security risk. That's connected to not getting on the bus, to not observing him while he's working because it turns out he's making a bomb. I think there's a disconnect between what you're saying Floor's obligation is. I'm not saying they had to supervise their employees. You're right about that. I'm not saying they didn't have to, but there's a disconnect between the negligence theory that you say you're pursuing and what actually caused the harm here.
Well, that's a jury question that's a question for the jury, Your Honor. If the jury accepts Floor's argument that their supervision of him for work-related purposes was sufficient, then we might lose at trial. But what we have alleged is that Floor was obligated to supervise Mr. Naib for his work, and that their failure to do so was the cause of the bombing. That's what the Army concluded in its report. The Army did not suggest that Floor had any security obligations. What they found was that Floor had a complete vacuum in supervision in this area, that Floor's supervision responsibility was clearly stated.
Can I ask you about something about the Army report? And I don't know if this is relevant or what to do with it. I totally understand that your reading of the Army report is that the Army report says over and over again, this is Floor's fault. And I mean no disrespect to the Army at all, but it does seem rather obvious to me that it would be in the Army's incentive to say over and over again that it's Floor's fault, and it's definitely not the Army's fault. Even though you can't sue the Army, even though the Army is completely immune from suit, the Army, for its own reasons, has perhaps an incentive to say it's totally not the Army's fault and it's totally our contractor's fault. So what do we do with that in assessing the political question part of this, and I guess the preemption?
Well, I'm certain that will be Floor's argument to the jury.
And it doesn't seem that implausible. I mean, you have to admit, it doesn't sound facially implausible that in a world in which something genuinely horrible happened. Obviously, a lot of things went wrong. And other than the bomber, obviously, other than the bomber, the two principally plausible responsible parties for this horrible thing happening are the Army did a bad job or the contractor did a bad job. And the fact that one of those two parties is going to say that the other one is the one who totally did a bad job, strikes me as fairly consistent with what we know about human nature. I guess I'll say it that way.
Well, and I don't disagree with that, Your Honor, and that is an argument to the jury as to whether Floor is responsible for this bombing. To get there, we have to get through this preemption question. And what the district court did that was an error was ignore the findings of the Army report. On summary judgment, this is an affirmative defense for which Floor bears the burden of proof. The judge cannot disregard evidence in the record. So even if she does not find the Army report to be persuasive for the reason that you articulated, Your Honor, she can't discount it. She also cannot disregard the contractual obligations, which delegated supervision responsibility to Floor. She can't disregard, even if you want to put aside the Army report, Floor itself admitted that everyone who was supposed to be supervising this man was a Floor employee or subcontractor. Floor gave an on the record in the testimony. They were questioned by the investigators. And he asked Floor straight out, who supervised this man on the night of the bombing? And there was no answer. The transcript says the man in charge of the NTV yard raised his hands as if to say, we don't know. The only question right now on preemption is whether there is a factual dispute on command authority. The Army's report itself creates that factual dispute. Floor says this is a security issue. Floor says that this is a negligent hiring issue. Specialist Hensley has never alleged that Floor was obligated to provide security. Specialist Hensley has never alleged that this case is about giving Mr. Naib access to the base. Instead, he has alleged that Floor was obligated through its contract to supervise this man for work purposes and that it failed to do so, and that failure was a cause of this bombing. For purposes of preemption, that should be enough to create an issue of fact that can get this case to the jury. And the district court erred when it concluded that there was no dispute. In order to do that, the district court necessarily had to accept Floor's framing of Specialist Hensley's claims, which we submit is improper. The claim is for negligent supervision and negligent retention. It is not for negligent hiring. It is not for negligent access to the base. Those are all arguments that Floor can make in its causation defense. You should blame the military for this.
But one question about the Second Circuit's decision in Badia. If the Supreme Court grants cert in that case, do you think we should hold off deciding this case? Because you're all arguing this case under our existing framework and the possibility that the Supreme Court might blow up our whole framework. Would that be a reason for us to put off deciding this?
I think that we should win this question under the Fourth Circuit's test. So I do not believe that there's any reason to hold a ruling on this. I know that the response brief is due in that case at the end of this month. So we're likely to see an order by the end of the summer. So it may be that just with the court's other work that it might not get to it in time, but we believe and urge this court to conclude that we should win this question under the existing Fourth Circuit framework. Thank you. I'll reserve the remainder of my time.
Thank you. Mr. Russell.
Thank you, Your Honors. May it please the court, my name is Dan Russell and I'm here on behalf of Fluor. The core allegation in this case is that Fluor's negligence caused an enemy attack on U.S. military forces at an overseas base in the middle of an active war zone. At the time of the attack, Fluor was performing mission-critical, non-combat support functions that were historically performed by uniformed soldiers. The district court held that the state law claims at issue here are barred under this court's combatant activities preemption test adopted in the burn pit case. On appeal, in an attempt to avoid the preemption issue, Specialist Hensley argues that this suicide bomber case is not about base security and not about military judgments. Specialist Hensley invites the court to narrowly focus on Fluor's conduct, and he claims that the battlefield context and the military judgments that governed Fluor's activities are simply not relevant. Your Honors, the court should reject such a myopic approach to the preemption inquiry. It is not consistent with this court's precedent. And beyond that, in an area of profoundly important and broad federal interests, it simply misses the forest for the trees.
Russell, I have two factual questions I haven't been able to figure out and strike me as potentially relevant that I was hoping you could help me out. Did the Army, I understand the Army mandated hiring Afghan nationals. Did the Army require Fluor to hire the bomber specifically?
The Army placed the bomber into the hiring pool and never warned Fluor that he had a Taliban past. And so
I understand that. And you didn't have to, and again, whether this is controlling or not, but I just want to make sure. The Army did not say hire that man.
They sponsored him specifically, placed him into the program for hiring. So I think he effectively...
Is everybody, wait, hold on. Is everybody who's placed in the pool for hiring, was every single one of those people hired?
They have to go through a military vetting process, but yes, they will be hired if the military sponsors them for hiring.
Well, before you, sorry, I want to make sure I understood the answer there because I'm not really clear on this. If Fluor had decided for whatever reason, this person didn't have the technical skills, they didn't like the way he dressed, whatever it was, are you saying that they had no discretion but to hire him, or they had the discretion to choose whether to hire him or somebody else?
The contract required Fluor, mandated Fluor to hire local nationals, and this individual was placed in the local national pool. There's nothing in the record specific to that, the question of consideration of NIAB specifically. However, the requirement in the contract pursuant to the Afghan First policy was that Fluor had to use a local national workforce.
All right, that's still not answering the question. Did they have the discretion to hire this bomber or to have denied him if they chose to do so?
Your Honor, I think that the combination of the contractual requirement and the military sponsorship of him effectively required Fluor to have hired him in the first place. But I don't think that is the issue. And I did want to address, Judge Hyten, to one of your questions.
I just have one other factual question. That's the front end. My other question, I promise, is my only factual question at the back end. Would the Army have forbidden Fluor from firing him? Like, say he's just, rather than being a suicide bomber, say he was just wretched at his job. Would the Army's contract with Fluor have forbidden Fluor from firing him?
The answer is there's nothing in the contract that would have specifically forbidden it. However, the facts as we know it are the military knew he had a Taliban past.
No, I'm not talking about the Taliban. I'm just talking about he's that if at some point the floor, I don't know, the manager on site was just like, this dude is awful at his job. He is just a terrible, legitimately terrible employee. So regardless of whether he has a tie to the Taliban or not, he's fired. Was there anything about Fleur's agreement with the army that would have prevented them from doing that?
I think that complying with the Afghan First policy would have.
No, they've got another Afghan. They're going to fire him and replace him with another Afghan national.
If the record had different facts in it showing that he was a horrible worker for years and years and years, I mean, I don't know the answer to that question specifically because I don't think it's been addressed.
But it seems, I mean, I guess it seems to be quite important to know the answer to this, right? If the army could, if Fleur had to hire him in the first place, and if Fleur could have fired him, but you're saying the record just doesn't tell us the answer to either of those questions.
I think the record reflects that there was a mandate to hire local nationals. There's no
but not
question
this
about
Afghan
that.
national.
There's a memo in the record from the military to the military saying we need to hire this individual as part of the Afghan First program to help reintegrate him into Afghan society. So there is specific evidence in the record saying hire this guy. And then beyond that, Your Honor asked a question earlier about whether there was any evidence indicating that Fleur knew of Naib's Taliban past. The district court opinion states plaintiff does not dispute that the military alone knew of the threat posed by Naib, including that he was a Taliban associate. That is an undisputed fact in the record for this court. Wanted to make sure that was clear. Your Honor, if I could continue, the next point I was actually going to make, Judge Agee, you made during the earlier argument, which is in order to assess the application of the preemption defense and the political question doctrine, this court must look at this case as it would actually be litigated and actually tried. And what we know at this stage of the proceeding is that this case squarely falls within the preemption test, because if this case proceeded to further discovery and a trial on the merits, and that's if a trial could even be held given the vast quantity of classified information at issue, if it did, inevitably, the result would be judicial scrutiny of wartime military decision-making. There are numerous military judgments that would be the centerpiece, the focal point of any further discovery and any trial in this case. And for example, and we've mentioned some of these, the military made a deliberate choice to bring a Taliban fighter onto the base for employment. That was a military decision. It was in furtherance of a military policy. The military chose not to warn Fleur. For whatever reason, the military decided it was best not to warn Fleur that this individual, Naib, was a Taliban fighter.
Opposing counsel seems to argue that in that circumstance, since the military cannot be found liable under South Carolina law, that doesn't make a difference.
Your Honor, it makes a difference because the result here will be judicial scrutiny and second guessing of wartime military judgments, which is precisely what the preemption test is designed to avoid. So regardless of the nuances of South Carolina law, even assuming for a second that that is applicable, it would only be applicable, if at all, to some portion of the political question analysis under this court's ruling. As to the preemption rule, which, as the district court held, is a broader rule, the question is whether or not Fleur's activities were subject to the military's command authority.
Can I ask you about that? Do you think under the steel company rule, could we decide the preemption question before deciding the political question doctrine, or do you think we have to decide political question first?
Your Honor, it's an interesting question. I don't think that the Supreme Court has addressed whether the steel company rule applies in this specific scenario.
And the only thing I could find is an invited amicus brief where the federal government took the position saying they think you could do preemption before political question, but that's all I could find.
And that was precisely where I was going to direct the court. There's two places I would. One, Tennant v. Doe is the case, the Solicitor General brief that you're referencing cites. And that's a case involving the Totten Bar, in which the Supreme Court held that it could dismiss a case based on the Totten Bar, which has to do with the courts have no place ruling on secret spy contracts. And so there was a question about subject matter jurisdiction, and then the Totten Bar, which was non-jurisdictional. The Supreme Court dismissed on the non-jurisdictional ground because it held that the purpose of the Totten Bar was to avoid the judicial inquiry at all. So I would say that there are parallels there to the preemption test here, which is designed in part to avoid the judicial inquiry into military decision-making. And so I do think that there is some room for this court
I
interpret.
assume your client would be happy with any decision that just ends with the word affirmed. You don't care how we get there?
That's a safe assumption, Your Honor. And the other authority I was going to point you to is the Fifth Circuit's decision in Fisher v. Halliburton, in which, albeit in a slightly different procedural posture, it was on 1292B appeal. The Fifth Circuit held that preemption barred the claims. In that case, it was the Defense Base Act preemption, and specifically stated it was not going to address the jurisdictional political question doctrine issue that had been raised. So there is some precedent out there for the court to bypass it. But as you said, an affirmance on either ground would certainly be welcome. And we do think that there are grounds in the record for both the political question doctrine and combatant activities preemption.
So how would the district court in the first instance be passing judgment on military decision making here? How would that manifest itself?
Your Honor, in a couple of different ways. To begin with, this is a tort case involving a claim of negligence. There has to be some finding of a standard of care or duty of care. And in this case, in trying to do that, inevitably, a number of military decisions would come under scrutiny, including the military decision not to warn Floor that they had a Taliban fighter amidst their workforce. And in attempting to craft a state tort duty of care as to what is a reasonable amount of supervision, you would have to take into consideration, you would have to evaluate the military's decision not to warn its contractor that it had this Taliban fighter within its workforce. Now, in addition, the issue of causation.
Would the court be evaluating that or simply acknowledging it as a fact?
Your Honor, I think it would be evaluating, it would be scrutinizing. There would be commanders, there would be subordinates that would be called to testify about the military failures that led to an enemy attack. And that process is precisely what the court's preemption rule is designed to prevent. The raking over the coals of military decisions in a wartime setting that inevitably will impact how the military operates in future engagements. That's a space that this court held. The federal government occupies the field. Introducing state tort law here would result in the word that's used in the burn pit decision is state law touching military judgments. It's going to be more than touching military judgments. If this case goes forward, discovery will be aimed at the military, and commanders will be forced to testify as to how this individual got explosive onto a military base, a secure base, and how the military force protection systems failed. It leads me to another point I wanted to make in response to Judge Rushing's question earlier. Judge Rushing, you had asked about the contractual obligation that Floor had. I want to be clear, that contractual obligation was a limited workplace supervision role at all times, including while Nayab was at his work site. The military alone was responsible for supervising him for purposes of base security. And for example, the military conducted canine sweeps of the workstation. And the only reason they did that is because they're responsible for ensuring he doesn't have a bomb. So they're doing that. They're conducting those types of canine sweeps. They're physically searching him every single day he comes onto the base. They're vetting him. They're conducting intelligence screening interviews with him, all because that is their role and their role alone. Floor doesn't have the discretion to conduct that kind of security. Under the contract, Floor was prohibited from performing any security functions. So I think that is
that kind of touches on what I think makes the precedent we have a little bit of an odd fit for this case, because we have precedent where a contractor's hired by the military to do a job. In doing the job, they injure someone. So they're hired to provide electricity. They provide electricity negligently and injure someone. They're hired to, fix the ramp for the tanks. The way they provide electricity to that, injure someone. Here, it's not the work. It's not the services that Floor was hired to provide that injured someone. It was, I know they're trying to say it's supervision, but this could happen no matter what job what service you're providing, right? That it's the fact that this person was an enemy combatant that was unknown. So I'm not sure that the test we've been given, it's all we have to work with, but I don't know if you have any thoughts on how that affects our analysis, or does that just mean we should be looking at, just at security supervision, even though plaintiff is trying to allege something a little different than that?
A couple of points, Your Honor. First, the plaintiff has alleged base security as a duty in the complaint. There's about a dozen places in the complaint that you look at where paragraph 240, for example, they refer to Fluor's obligation to provide base security. Paragraph 244D, they refer to Fluor's contractual obligation and duty to preserve base security. So that is in the complaint. Now, I think more importantly, to your question, that the component of the case does distinguish this. This is not an instance in which a worker at a maintenance shop, did a bad job changing the brakes or changing the oil, and then an accident happened. The allegation is that Fluor should have taken other action to stop an enemy attack. And I do think that takes this into another category. I do think there are parallels between this case and, say, Burn Pit, in which the military made a number of foundational decisions that ultimately governed how the contractor acted. So in Burn Pit, for example, the military decided the method of waste disposal to use burn pits. The military decided where to place them, and the military decided what to put in them. The military monitored air emissions to ensure that it didn't believe there was an inordinate risk from them. Here, the military decided as a policy matter to hire local nationals and decided to hire this specific individual. They sponsored him for employment.
You don't have the level of control like you had in Burn Pit. And maybe you don't have to, because Burn Pit was on political question. It wasn't on preemption in the end.
Well, Your Honor, I do think we have the level of control, and part of it is because this is a security issue and not a case in which there's an allegation of poor maintenance. With respect to security issues, the military absolutely controlled what Fluor could and could not do. Fluor was not allowed to bring on additional supervision at the workplace. It wanted to do that. It offered to do that.
What's the evidence that they weren't allowed to bring on any supervision? The only evidence I'm aware of is you asked for more money to do 24-hour surveillance, and the military said no. What evidence is there that you were not allowed to do any? I mean, I guess given what we know about the facts of this case as alleged, it would be shocking to me that you were not allowed to do any more supervision, because I think at least potentially the record is read as there was no supervision whatsoever.
Your Honor, there is a difference between supervision for the purpose of performing the work and supervision for the purpose of security. The former was what was required under the contract, and we acknowledge that. The latter was not only not required, but it was prohibited. Fluor was prohibited from performing any security function. That's one point. They couldn't perform a security function.
You couldn't decide whether he could access the base. I agree there's evidence that you had no ability to do that. And when you asked to follow him around for 24 hours and be paid more money, when you asked to follow him around the whole time, the Army told you, we're not going to pay for you to do that. But what is the evidence that you were forbidden from providing any more supervision than you did?
Your Honor, let me make sure my point is clear. The evidence in the record is that Fluor came to the military and proposed enhanced escorting. The existing base policy that the military established did not allow escorting at the work site. It required escorting at other places, but specifically excluded the work site from the policy. So there was a gap in the policy, and Fluor proposed filling that gap, and the military said no. And why is that relevant here? If a state tort duty were to be crafted as to what's the reasonable level of supervision, that's going to run headlong into that military decision that should govern. The military should be able to decide, whether or not to put forward more resources into that workplace supervision function. And allowing state tort law to control it is going to unsettle what is right now an exclusively federal responsibility.
Well, did you need more resources to allegations to determine that this fellow didn't need any tools, but he was checking out tools all the time that he didn't need for his job? He was sleeping on the job. He was just gone sometimes. Was there any restriction in the contract that prohibited Fluor from observing those things and taking action against an employee who did them?
Your Honor, I don't believe there's a restriction that prohibited Fluor from observing those things. I just don't think that that's the inquiry under this court's preemption rule or under the political question doctrine. And again, I think, you know, what brings this case over the line and beyond even Burn Pit or Taylor Carmichael is that this is a case in which an enemy attacked U.S. forces, and inserting state tort law into that equation is going to do harm to the federal interests that are identified in the Burn Pit decision, which include avoiding judicial scrutiny of military judgments. This case,
Can I just get a clarification on that? Because I feel like at times your argument blends two things. I think we can all agree that the precedent says we can't question, you need to avoid questioning military judgments. But I think at times your arguments seem to come up to me to say, there is no, we need to avoid judicial proceedings that might embarrass the military by making the military look bad in some people's eyes, right? There is no freestanding principle that we can't let any lawsuit go forward that might embarrass the military or make the military look bad as an abstract matter, right?
Your Honor, I don't know that embarrassment is the issue under the case law. I think it's judicial scrutiny of military work.
Right, but I guess what I'm saying is you agree that there is a distinction between judicial scrutiny, which is forbidden, and a legal proceeding that's going to result in some evidence that makes the military look bad.
Under the facts here, I'm not sure that there is no pathway under which a proceeding.
No, I'm just asking you if in principle you agree those are different things.
I think that there are judicial proceedings that sometimes take place that involve military actions and not
Some
all
of which make the military look bad.
Yeah, yes, Your Honor. And I think this court has said that not all military actions are, outside of the review of the judiciary, but this one is. And I wanted to make one or two other points before I sat down. And one of them is to get back to this issue of whether the military mandated the use of NIAB and the local national workforce. The day after this attack, the military effectively fired 1,500 local nationals and got them off the base. That illustrates the level of control that the military had over the workforce. If the military had made that decision 2 days earlier, we wouldn't be here. The military controlled the fact that those 1,500 local nationals were on the base and they decided to effectively fire them. The contract might say that there's a technical abstract obligation on Fluor to hire and fire, but in reality on the ground and in this record, it's clear that the military controlled that. Thank you, Your Honors.
Thank you very much. Mr. Snyder, you've got some time in rebuttal.
Yes, Your Honor, just a few quick points. On the factual question.
Yes, our opposing counsel says that in the trial of this case, that it's necessarily going to involve military personnel as witnesses, a lot of military documents, some of which may be classified, some of which aren't, and that will inevitably involve judgments by a judicial authority on the judgments of the military. What do you say to that?
This court's holding in Burn Pit and the Third Circuit's holding in Harris make it clear that the fact that there may be testimony from military officials is not enough to get to a judicial evaluation of the military's conduct. Essentially here, Fluor is going to present a factual defense. They're going to say the Army allowed the explosives to be smuggled onto the base. The Army cleared this man for hiring. And then the jury's going to have to decide not whether this bombing was the Army's fault.
Get into a military security issue of how it went about vetting foreign nationals in a war zone, all sorts of things of that nature that would seem to be very sensitive for judicial review.
They may be sensitive issue, but under this court's precedent and the Third Circuit's precedent, that simply having military people testify in a case about policies, about facts, is not enough to get to judicial evaluation. The only question the jury is going to have to decide in this case is, did Fluor cause this bombing, and what are the damages if they agree that it did?
Mr. Snyder, could I ask you to address your friend on the other side's point about how the military brought canine units around to sniff for bombs at the work site, and that suggests that it was really, that even within the base, the military was in charge of security, not the contractor?
It is undisputed that the military had effective command over security in the base. The reference to canine sweeps is one paragraph in an affidavit from a Fluor employee saying that at times the military did that. There's no evidence that the military ever did that during the time period when Mr. Nayeb was building the bomb. And there may be some overlapping authority there as to security. And if this was a negligent security case, that could be a problem for us. But to Judge Rushing's point, Fluor was obligated, they were hired to provide labor and to supervise that labor on the base. And that failure to supervise their labor was a cause of this bombing. The claim is not preempted because we know that Mr. Nayyab committed an intentional attack. The focus here is what is the conduct that is at issue and whether the Army actually commanded that conduct. And there's simply no evidence. Mr. Russell acknowledged there's a gap in the policy as far as escort goes. And that gap was filled by Fluor's discretion to supervise its own employees. And I would just note one thing, Your Honor. The military did, in fact, find that Fluor had failed to terminate this man and that it was obligated to do so. In the Army report, which is in the record at JA 121, they found that the lack of formal counseling or disciplinary action showed a failure to enforce a work-related standard of performance, and it was the unjustified retention of Mr. Nayyab. Thank you, Your Honor.
Thank you very much. We appreciate the argument from both counsel. As you all probably are aware, we normally come down and greet counsel after argument, but that's not in our operating procedures at this point. So we hope you'll come back on another occasion and we'll be able to do that. So with that, I'll ask the clerk to